Well, I received the paper book on 5th.
Yes. Yes.
Problem.
Right.
A very short point is involved. My lord, the NIT was not widely published. Paper publication was not there. It was only.
My lord, work has been awarded, my lord, and there is an existing structure, what I have, that has to be first dismantled and then the work has.
Awarded, but then the
Awarded
work
in
has
the
not
month
started,
of,
my lord, because there is an
March.
interim order in this appeal. Innocuous order otherwise that any work order issue will be subject in a court. But I am got a very short and simple point. Publication, yes. My other points I took, I practically abandoned. Only point is, my lord, there are notifications by the state government specifically saying that there has to be newspaper publication. And second aspect that I'll show, my lord, from the CPWD manual, from the GFR, that it is necessary. Secondly, my lord, in all, I have annexed documents in all NITs, except this one, there were paper publication giving the website, the address in the newspaper. There may be short press note also, no problem. But then the website, I have to get the website from the newspaper. And that was done my lord, invariably in all the NITs, except this one. Single judges said, my lord, that CPWD manual was followed, GFR was followed, but that is not correct, my lord. That is not correct. I'll show, my lord. I'll just take my lord. No, my lord, I cannot ask for review because that point has been discussed. But the decision is not correct. This is my humble submission before Lord. Lord will kindly take just 15-20 minutes, I'll finish the entire matter. Very short point, a few documents I'll show, then your Lordship can kindly decide. Now, NIT, I did not just point out, this is not very relevant in this case. Yet I'm just showing it. Page 78 is the NIT. The purpose of showing this page at page 78, my lord. My lord, this is the NIT. This is NIT published, my lord, for the purpose of upgradation of hospital to 300 bedded. It is there in the table, Lord will find at page 78. This is for upgradation of Bakin Parting General Hospital, Pasigar, to 300 bedded hospital in East Siang district, Arunachal. Lord, I am showing this page to show that even this NIT was printed in a format to be published in the newspaper. Lord, will kindly see down below, the address is given. Like all other NITs, I have annexed documents, maybe at least 10 such NITs, my lord, where paper publications were there. Even this one also in the format of a publication in the newspaper. But ultimately it was not done. Now you will also kindly see page 43. Lordship may kindly state to come to page 245. It's 245. None 2018.
What is that?
My lord. My lord, this is a notification by the state government.
Yes.
My lord, if your lordship kindly permits me, my lord, before that, I'll just show one document which is related to this, which is available at page 266.
Yes.
266, my lord. This has got direct reference to that, man. That is my issue. 266 is a notification about published by the my lord, Government of Arunachal, Department of Information and Public Relations, Itanagar.
Yes.
When it's a guidelines for issue of government advertisements.
Oh.
The governor of Arunachal Pradesh is pleased to approve the following guidelines to regulate the issue, release of government advertisements, classified and display to the print media.
Oh.
A to 4, we can skip, my lord. Lordship may kindly see straightway. Clause 5.
Oh.
Any advertisement, display or classified shall not be issued to more than 3 local dailies. While issuing advertisements, particularly tenders, all departments need to follow provisions under the General Financial Rules (GFR) for maximum publicity. One national or regional daily, as the case may be, can be included on requisition from the concerned office, department, or as deemed fit by the DIPR. This restriction shall not apply to advertisement of general nature issued by DIPR, etc. So this paper publication is there in the first notification of 30th January 2018.
Okay, but this guideline is primarily regulating the advertisement issued in newspaper.
Yes,
As advised in newspaper, what should be done, what not.
exactly.
But
Now,
this is not a mandate that in every and cannot be.
in the
that
NIT
in-
matters.
It should be
My
it's
lord.
mandate of NIT.
Well, I have shown this because this has got relation to page 245. That is why.
Okay, let us see page 50.
My lord. 245 is a notification of 24th September 2019.
Yes.
Notification.
Hmm.
Consequent upon amendment of General Financial Rules, GFR, Rule 161, 1, 183, 2, and 2012 of 2017, in respect of tender advertisement for procurement of goods and services, the need for publishing advertisements in the newspapers for procurement of goods and services has been done away with. Not necessary now.
Hmm.
This has now been replaced by mandatory e-publishing of advertisement on Central Public Procurement Portal (CPPP) at www.eprocure.gov.in, Government of E-Market Placement (GEM) and websites of the department. Therefore, all the departments, office of the Government of AP are directed to strictly adhere to the provisions contained in the GFR 2017 regarding the publication of advertisement for procurement of works, goods and services, and publish the tender through government e-procurement system of NIC, so links given 1, 2, 3. In case it is felt that advertisement is necessary to be published in the newspaper, approval of the finance department shall be obtained prior to its publication. This was the notification, because earlier there was a necessity of publishing all advertisements in newspaper. That is why now they have cleared that there was
It's a days of internet.
Yeah, intern, exactly. Now, not to make, kindly see the next page, 246.
Yes, what is?
Next page. 19th of August 2020. In supersession of earlier government notification dated 11th October, dated 17th July 2018, which I have just now read, my lord, and 24th September.
No, okay.
Sorry, my second one I have read.
Second one.
24th September 2019. Mandating procurement of goods, services of all government departments, directors, associate offices, etc., etc. In view of the government policy of vocal or local and Atmanirbhar, fourth time I am reading, my lord, Bharat, to encourage local entrepreneurs, the first priority on any procurement of goods and services shall be done locally through normal tender. And further, that only when items are not available locally through normal tender, the procurement shall be done through government e-market (GEM). This notification shall come into force with immediate effect.
Yes.
And this notification is till today valid.
Yes.
Now, Lordship may kindly turn to well, the CPWD manual is there. GFR is the relevant provisions I am just reading, my lord. Lordship may kindly see page 224, ma'am. 224. Well, this NIT is of 2023. So similar provisions are there. I'm just showing you. This is the page 224 is the CPW manual 2019. Similar provisions are there in 2022 manual, which your lordship will find as page 235.
235.
35. The relevant portion is 237. Clause 4.4 at the bottom, my lord. Page 237.
Yes.
Clause 4.4, e-tendering. As per Rule 159 and 160 of GFR 2017, it is mandatory to e-publish all tender enquiries, requests for proposal, requests for expression of interest, notice for pre-qualification, registration, or any other notice inviting bids or proposals in any form, corrigendum thereon, and details of bids awards on the Central Public Procurement Portal, that is CPPP, as well as website of the department. And to receive all bids through e-procurement portal, etc. So they have to publish first in the CPPP as well as in the website of the department. Now, lordship may kindly see. Now, page 243, man. It's about publicity of the tenders. Clause 4.1.
Just a minute. Now page
Page 243, man.
243.
Page.
Yes.
And clause 4.12, publicity of tenders.
Yeah.
All tenders of any amount shall be invited through
4.1.4.
4.12 on top line.
12.
Publicity of tenders. All tenders of any amount shall be invited through e-tendering system. Notices of all the works, irrespective of their value, shall be published on the website etender.cpwd.gov.in as instructed from time to time. Once published on the website, the tender notices will also become available on www.eprocure.gov.in through system link. In none of these links, none of these addresses, the NIT was published. Now, lordship may kindly turn to page 2.
Yes.
Well, the GFR rules I am referring to, the relevant portion.
Page
Starts from page 248.
relevant.
Relevant is 249. The left hand side, my lord, rule 159. E-publishing. It is mandatory for all ministries, departments of the central government, their attached and subordinate officers and autonomous and statutory bodies to publish their tender inquiries, corrigenda thereon, and details of bid awards on the Central Public Procurement Portal, that is CPP. It was not done. Then, my lord, right hand side, rule 160, lord, you may kindly see, e-procurement. It is mandatory for ministries, departments to receive all bids through e-procurement portals in respect of all procurements. It was not done. Then down below, my lord, 161. Advertised tender inquiry, subject to exceptions incorporated under Rule 154, 155, 162, and 166. Invitation to tenders by advertisement should be used for procurement of goods of estimated value of ₹25 lakhs. Advertisement in such cases should be given on CPPP and www.eprocure.gov.in and on GM. An organization having its own website should also publish all its advertised tender inquiries on the website. So in addition to this CPPP and this eprocure.gov.in, you have to give it in your department's website. Then Roman 3 Lord Mechanic. The advertisements for invitation of a tender should give the complete web address from where the bidding documents can be downloaded. What does this mean, Miller? There should be advertisement giving the, where from I'll get the address. It says advertisements for invitation of tenders should give the complete web address. So there has to be an advertisement which will contain the web address, which they have been doing. In all tenders, they have
So
given.
you want to say advertisement means a publication in paper?
My lord. Why I am saying, my lord? Otherwise, from where do I get the, a department may have.
You are a businessman. The website is in etendersprocurement.com and it says everything can be downloaded. Come to your tender document.
My lord.
Page 1, that page 78. The tender forms and other details can be obtained from arunachaltenders.gov.in.
My submission is when the documents, first of all, the government of Arunachal's notification says there has to be a newspaper publication, normal tender. That is for vocal for local. And secondly, these documents say that it has to be in the CPPP. CPPP you have admittedly not done. Then the e-procure address, URL address, there also it was not given. Now, these documents, GFR and this CPWD manual 2022 says that in addition to this, you have to give it in your department's web address. Now, they have given only in the third one and not to other two, so that others do not get any information. This is my humble submission, ma'am. Lordship, here it says advertisements for invitation of tenders should give the complete web address. So this advertisement has to be named. Maybe what they do is they give a press note sometimes. A small in
What
box.
was the bid system? 2 bid.
2 bit.
And you did not even participate.
I could not
because you are according to your unwed.
Yes. When
Then prize bid was opened. Then award was given.
No, I think
You let him the bid. In a given case, you may consider this.
Here is a case, there were only ultimately there were 2 bidders only left. And estimated cost of the work is 100 crore. Supreme Court says there has to be wide publicity for distribution of state largesse, all should get equal opportunity. I only wanted an opportunity to participate. I am a competent bidder, my lord, there is absolutely no denial. They did not file any affidavit. I only wanted to participate, that's all. My prayer is that I should not be given the work order. I want to participate, that's all. Now, Lordship, may kindly have a look at the finding recorded by Honorable Single Judge.
Yes.
Lordship, may straightway come to paragraph 5. I'll take very less time and offering lordships.
Paragraph 5.
Paragraph 5. Hello, I'm sorry, para 4, 5. First,
Just a minute.
Para 4 is my submission, my lord. Para 4 at page 264. My lord.
Of the paragraph 4 of the judgment.
Yes, ma'am. At page 364. 364. My lord, are these submissions made by me that fair opportunity to compete, my lord, was not given, wide publicity was not given, and the notification of 19th of August 2020, whereby it says that for local entrepreneurs, normal tender process should be followed. So in order to uphold the concept of local for vocal, and the submissions of the.
You are reading it, paragraph 4 of the judgment.
Yes, madam. Page 364, madam.
Mr. K. Pottam.
My lord. That was submission on behalf of the petition. So I have raised, which I have now argued before lordship.
Yes.
Lordship need not read that. Now, if your lordship wants to straightway come to the findings, page 368 at para 8, madam. 8 and 9 are the findings. I have heard so and so. From the projection made by the party, the issue to be decided is whether there is infirmity in the manner in which the NIT data so and so has been published. That is by way of e-tender only and without making any paper publication. The learned counsel for the petition have relied upon the notification dated 19th of August 2020, which was issued by the Chief Secretary to the Government of Arunachal Pradesh, providing that priority on procurement of goods and services shall be done locally through normal tender, and that only when items are not available locally through normal tender, the procurement shall be done through government e-market. It may be seen that the nature of the work which was tendered is for upgradation of General Hospital at Pasighar to 300-bedded hospital for an estimated cost of rupees 99.03 crores. The work tendered is also on turnkey and EPC mode. There is no dispute to the fact that CPWD manual is applicable to the state of Arunachal Pradesh. Clause 17.1 CPWD manual 2014 provides for wide publicity of tenders. Clause 17.1 provides that wide publicity should be given to notice inviting tenders in most open and public manner, possibly by advertisement in websites, press, and by notice in English, Hindi, and written language of the district concerned amongst others. However, the CPWD manual 2019, the publicity of tenders is provided under clause 412, which states that all tenders of any amount shall be invited through e-tendering system. Notice for all works in irrespective of their value shall be published on the website as instructed from time to time. Once published on the website, the tender notice will also become available through system link. It further provides that in exceptional cases, if press publicity is be given apart from website publicity.
Now, paragraph 9, where it says against the e-tender notified, as many as four firms which include the private restaurants were able to participate. Meaning thereby, what is this?
I'm not participating.
Not party, but how these conclusions were made that you are all eligible other four parties?
From where or see?
You read paragraph 9.
There are 9.
Records produced by the learned senior government, it is seen that process was followed in the finalization and uploading of e-tender in the website as per the guidelines of CPW and GFR. Against the e-tender notified, paragraph 9 of the judgment.
Paragraph 9. Please.
Just read it. Against the e-tender notified.
Fourth line. Yes. Against the e-tender notified.
As many as four firms which include the private were able to participate. How a record reflects that? That's we want to know.
No, well,
According to the learned
there were 2 repetitions panel here. I didn't participate. The other repetition is there. They participated. Both the repetitions were dismissed.
Okay.
2 repetitions.
How many people? How many parties participated in the tender?
Altogether 4 participated. Only 4.
You cannot say only for 100 crores project.
Well, in a matter, humble submitted before Lordship, my lord. This is the only situation, only case where paper publication was not given. There is no response to this, my lord. They have to justify that in all tenders, irrespective of value. I have annexed, my lord, those NITs. At least a press notice there in the newspaper, so as to give them the address of the website. But a department may have 10 websites for different purpose. Which one will contain what? I do not know, my lord.
Yes. Yes. Proceed.
Well, one paragraph from there, they did not file any affidavit in opposition before the on single judge. Before the division bench, my lord, they have filed one affidavit, state. From there, I can just show one paragraph. Because the writ petition was dismissed on the same day. Of filing.
At what stage you approach this court?
I'll just find out. Well, possibly I'm told, but I'm not very sure. Before the award was passed, we
After conclusion of the tender, technical bids were open, or price bids were open.
minor. Well, this para page 4 of their affidavit, which will be small d. Small d.
Yes.
Minor. It will be 3D. It starts from page 4. page 4, madam, that since the tender of so-and-so was online tender, which was published in the website http Arunachal tender on 24/6/2023 at 10:30 hours and was not published in the newspaper as was not required as government order number so-and-so dated 24th September 2019. They are referring to this 19, not the later one, wherein it has been clearly stated that the need for publishing advertisement in newspaper for procurement of goods and services has been done away with. Therefore, all department offices of the government of AP were directed to strictly adhere to
Legal notice of served upon whom?
legal
And
notice
who
was
served?
no, legal notice was served by an association, not by us.
Association served by, association served legal notice.
Because association also filed one writ petition, there is a writ petition was dismissed on the ground of locus. Principal Secretary, Commissioner PWD. This paragraph, they are very clear that 2020 notification, August 2020, they have ignored, which still holds the field, man.
Yes.
Page. Now, Lordship, may I kindly have a look at page 254.
Yes.
Page 254, man.
254.
Man.
Yes.
This is the normal practice followed. This is a paper publication, notice is there, and then address is given. Rest, my lord, entire process of the tender will be through e-tender, through the website. But then this is given so that people get the information and the website, address of the website. Next page also same, thereafter next page also same, then subsequent. Then from 272 onwards, I have given a number of, my lord,
Yes.
page 272 onwards. 1, 2, 3, all. Well, I have taken a specific stand that in all cases,
Yes.
my last submission, the government of Arunachal Pradesh doesn't have their own manual, so they strictly follow.
That
the
there is
CPW
no doubt
manual
about. Even the
20
judgment it is
Yes,
recorded.
22 and the GFR rules.
Hmm.
They themselves have said they will follow GFR.
Yes.
Now, the websites given in the CPW manual of 2022 and also the GFR, they have not published, admittedly. So
Basically, that is your ground,
My lord.
that it is mandated to be published in 3 portals,
Yes.
you have published in 1.
in one. And that portal is nowhere there either in the CPW manual or in the
Yes.
And that is why, my lord, every time they publish my lord, in NIT, they invariably give a publication in the newspaper and then where the address is given. I have shown. And I have taken specific stand in all such cases, they have done it in this way, except in this one, in the entire state of Arunachal Pradesh. my lord. That is my humble submission.
Okay. Yes, state.
My lord, basically what I have understood, my lord, there are 3 points raised by my senior, my lord. First, that the
Well, one judgment actually I wanted to cite. Just 2-3 lines. man. The Lordship is aware that Meerut Development Authority. We do.
Which paragraph?
Well, para 20, 27 and 28. The bidders participating in the tender process have no other right except the right to equality and fair treatment in the matter of evaluation of competitive bids offered by the interested
yes.
persons. Well, Lordship, this
No
specific
doubt
line,
about that.
one cannot change the terms and conditions. I'm sorry, ma'am, that line before that, offered by interested persons in response to notice inviting tenders in a transparent manner and free from hidden agenda. And the next paragraph is just 3 lines. It is well settled that law and needs no restatement at our hands. The disposal of public property by the state or its instrumentalities partakes the character of a trust. The methods to be adopted for disposal of public property must be fair and transparent, providing an opportunity to all the interested persons to participate in the process. Please prepare. I'm sorry, ma'am.
So, my lord, basically what I have understood, my lord, there are 3 vital points raised by my senior. First is that the CPWD manual is applicable to the state of Arunachal Pradesh and has to be strictly followed in total. Secondly, that there is a notification of 2020 whereby FSS is for local for vocal or vocal for local. And the third one is that other tenders published by the same department, advertised by the same department were published in some newspapers, my lord. Why not this? My lord, to the first point, my lord, if my lord will knows the CPWD manual, and there is another Central Works Manual for Procurement of Works, my lord, 2022. These are basically made for the central government department, my lord. That has been followed. The procedures laid down in those manuals are being followed in the state, my lord. Now, the state has their own portals, my lord. We cannot go and advertise it in the central portal, my lord. We have the state's own portal. The state departments have their own websites now. We advertise in the notified portals of the state government. My lord will have seen notification of 2019, wherein certain portals, GM and portals have been given. The advertisement of this tender was also in that portal.
So according to you, in terms of the notification of the state, where 3 websites are
Yes.
prescribed, in all those 3, it was established.
Yes,
Published.
published. We have done in our own state's portal. And second,
And your case is that until and unless it's a central government procurement, we will not permit it to upload our advertisement
Yes,
in
ma'am.
this portal because it belongs, we follow the
procedures.
procedure, but that portal do not belong to us.
Yes, ma'am. That is true. And secondly, my lord, the second point urge is that the vocal for local, my lord, that my lord talks about the procurement of goods and services, my lord. Here it is the procurement of works, my lord. And in our affidavit, my lord, we have annexed the relevant portion of the procurement of works 2022, the relevant portion, my lord. I have this is it is very voluminous, so I have this xerox the relevant portion, my lord. Otherwise, it's very voluminous.
Yes.
In this, my lord, internal page 54, my lord,
Page 54.
page 54,
Yes.
down below. 4.3, this is Manual for procurement of works. My lord, this is not CPW manual. It says it is mandatory for all ministries, departments of the central government, their attached and subordinate office and the autonomous statutory bodies to publish their tender inquiries, corrigenda thereon and details of bid awards on the central public procurement portal. If the department has its own website, e-procurement portal, it should also publish all the advertised tender inquiries on such website portal also. GFR 2017 has dispensed with the advertisements in newspaper. Clearly it says, however, in exceptional circumstances, procuring entities may issue the advertisement in newspaper as deemed fit. Such advertisements should also consist the link of a website from where the detailed advertisement and bidding document can be seen and downloaded. Individual cases are cases where confidentiality is required for reasons of national security would be exempted from the mandatory e-public publishing requirement. The decision to exempt any case on the said grounds should be approved by the secretary of the ministry department with the concurrence of the.
What is the importance?
My lord, here GFR 2017 has done away. If required, then newspaper publication.
That is
Yes.
case also. There is no doubt about that. That is dispensed with.
So newspaper
Publication.
publication is
Each case is that even if it is a not newspaper, 3 portals are required, that is not been given. Not on newspaper. His newspaper case is that at least newspaper you ought to have been said that we have issued a tender, please go to the web portal. This is his case.
yes, ma'am. Our case is that it is not required. Yes. Publication. The second point urged by my learned senior is that my lord, I would like
Now we want to know that he says it was in the advertisement, it is said in arunachaltenders.com
yes, ma'am.
that it is published in others. Where is your statement and where do you get that?
So my lord, no, in our affidavit, we have said that it has been published in that portal.
All three according.
No, my lord.
Where
it
is the
is-
statement?
Page 4 of our affidavit, my lord.
Page
4. Page 4, para D.
Page 4, para D.
Yes, ma'am. 246.
Arunachal Tenders Gopin at
Yes, we have published here. The other 3, my lord,
you made a statement that as per your guidelines, there is to be publications in 3 portals.
no, my lord.
Huh?
No, my lord. We are required, if we have our own website or the
Let us see that
the-
your notification.
notification is
Yes,
at
where is
page
Mr.
245.
Majumdar?
245.
245.
245 and 246. 245 is being superseded by 246.
Okay.
They are not referring to 246.
246.
Yes, my lord. 245 will see, here the portals are given.
That has been superseded.
245, there are 3 web portals.
Yes, ma'am.
E-procurement, Arunachal Tenders and GEM opt-in.
Hmm.
Huh. Now, 19th August 2020, it was superseded. Isn't that it?
Yes, my lord.
Now what it says?
But superseded in the sense only to the.
Just a minute. What do you mean by normal tender, Mr. Majumdar?
Normal tender means the normal process that
Normal, what is the normal process?
normal tender means not e-tender. Normal tender means otherwise, what else do you understand? Normal tender means not e-tender. Whole thing is normal.
So according to you, whatever project is taken in Arunachal,
Right.
there shall not be any e-procurement.
I'm not really saying that. If you.
No, you'll have to, because this is according to normal tender
Absolutely,
means.
I'm relying on this 2020 notification, which
Hmm.
say that first of all, the earlier notification of 2019 is superseded.
Hmm.
Now, their stand is that we have published in the website given in the 2019 notification,
Nothing.
but that is superseded.
Not all superseded in certain
Certain
contingencies.
contingencies.
Yes.
Local for, vocal for local.
Vocal for
It says-
local.
Again, it says normal tender, my lord. What will be the meaning of the expression, my lord, normal tender?
Okay, fine. That is not the issue in this writ petition.
Fine.
Rightly, wrongly, in 3 portals it is published. eProcure.gov.in, Arunachal Tenders Gov.in, GEM Gov.
No, they have not published. They
We
have
have
done
published
only
in
in
one
Arunachal tender.
You have published it one. Okay,
One,
if
one.
it is published in one, you are relying on 19th of August 2000, saying that this will not suffice. You will have to do as per local for vocal tender. This is your case.
My lord, I'm saying that even if you do it through e-tender, no difficulty. But let us know the website. You make a public on your.
That we understand. That
But-
part we understand.
but
But you say
para-
that at least give an advertisement saying that these are available on this.
Yes,
address.
and
That will deal with.
and I have taken a specific stand in paragraph 15 of the writ petition that is not denied, madam.
Okay, fine. That is fine. That we understand. That was not given. That is fine.
Items are not available located.
Construction, like delayed,
My lord,
And CPWD manual is also very clear. In addition to the other 2 portals, you can give it in the portal of the department. And they have done it only in the portal of the department and not in the other.
So what they're saying is, they are following the procedure. They have adopted it.
My lord.
But since they are having the discretion to have their own.
Okay, we understand. Yes,
my lord, regarding the 3 portals
yes,
given,
third point.
third point, my lord,
Three portal, yes.
that in the 2019 notification itself, which my learned senior claims to have been superseded. Here it says that anyone, it does not specifically says that it should be published in all these 3. It says what we can understand is any one of the 3 portals. And the last third portal, GEM Gov.
Just one
Got it.
second, let us see, it's 245.
Second para, my lord, therefore, all the departments, offices of the government of Arunachal Pradesh are directed to strictly adhere to the provisions contained in the GFR 2017 regarding the publication of advertisement for procurement of works, goods, and services, and publish the tender through government e-procurement system of NIC so and so through UR links only. 1, 2, and 3.
Okay.
Does not say that it should be published in all these 3.
Okay. Yes, next.
My lord, and that the next notification, my lord, vocal for local, my lord, I don't need to be, because it is for the procurement of goods which are locally available, and that's why the portal name, GEM, government e-marketing, that has also been reflected here. Our contention is the procurement of works.
Yes. Now, you have not published in EGM. Then how will you say that?
My lord, we have published this in Arunachal tenders gov.in as per the.
That is the GEM portal for Arunachal.
Yes, my lord, this is the this. Three portals are given in 2019 notification. We have published in one of them. The second one, Arunachal tenders.gov.in.
No, his case is, please understand, his
Yes.
case is that, okay, if not locally available, in terms of this notification of for 19th August 2024, you will have to procure through it government e-market GEM.
Yes, my lord.
And you have not done that.
Yes, my lord. We say that this is not a procurement of goods, my lord. or services, we say it's a procurement of works, my lord. That is in our stand.
Service means what?
My lord, works, my lord, that's
Where
why,
is it? Is anything defined again in goods and services?
my lord,
You are saying will not to show us that it is defined at work contract is different from service.
our
Don't
affidavit.
say, your affidavit will not do, substantiate it. If
This
you
is
dig into
basically-
that, we will also dig that.
Yes, my lord. Basically, what it says is those available products locally available, my lord. For that only, my lord. We
So
can,
for that only, notification says that if not available, then through GM.
yes, ma'am.
Then
And in any case, my lord,
why any case?
but since this
Then
is
it is not in GM.
what my submission will be, that this was not a procurement of goods which for
So therefore show us that goods and services are defined in this local for vocal act or rules.
of course that is not
whatsoever.
defined, my lord. Otherwise, the
Not
works,
defined. So service means a service of a contractor. Contractor will have to pay GST on his contractor bill. That is the service.
procurement
Service
of
means
works.
not that the contractor
Well-
will come and clean your building with a jaru posa. It's not service.
That's why in our affidavit, we have annexed that the manual for procurement of works, 2022.
Hmm.
Manual for procurement of works.
Okay. Yes, Fukan.
I have filed an affidavit. I'll just take one paragraph to your lordships and I'll leave it on that. Your lordships will be clear on that. I have filed an affidavit.
Yes,
Yes,
respond number 4.
yes. May I just read that affidavit? Just one paragraph.
Hmm.
I'm relying on page internal 2, paragraph number 4.
Yes.
The last line. The last line, para 4.
Hmm.
In pursuant to the NIT dated so-and-so, issued by the Executive Engineer, Arunachal Pradesh Public Works Department, Pasighat. May I read your lordships?
Yes.
Yes. Internal page 2, last line, and then I'm turn to page 3. Pasighat for upgradation of Bankim Patin General Hospital, Pasighat.
Hmm.
300-bedded hospital in the East Siang district as an estimate cost of 99.03 crores. The answering dependent had participated in the bidding process, being eligible, registered the contract processing and requisite criteria laid down in the said NIT dated 22/6/2023. That your lordships had asked these questions, therefore I'm replying. There were total 4 bidders participated in the bidding process along with the answering respondent. Upon evaluation of a technical bid on 14/7/2023, this is July, out of which 2 or 4 bidders were declared to be technically qualified and admitted in the financial evaluations of the bid. So the process now being followed. Thereafter, a writ petition number 349 of 2023 came to be filed by the Arunachal Pradesh Registered Contract Association, challenging that NIT up to that. This is the first round of litigation that happened, wherein an interim order of status quo was passed by the learned single judge of this honorable court by order dated so-and-so. The said writ petition was, however, dismissed on 7/8/2000. This is already annexed in this on the ground.
Writ petition was filed, tell us.
That writ petition, your lordships, was filed. The order is,
Forget about the order, date of filing.
when was it? I just give it to your lordships. The order that by dismissal is 7th of August. I just give you a list of the date on which has been filed. May I just read further? I just give you a date in 1 minute, your lordships. The said writ petition was, however, dismissed by the order dated 7/8/2023 on the ground of lack of locus standi to challenge the NIT dated 22/6. Thereafter, the financial bid was technically qualified bidders were opened on 9th of August, whereupon the bid of the answering respondent was declared to be lowest L1 and remaining constructions were declared to be L2. Now, your lordships have asked how many people have participated in this
4, I
contract.
have read it.
That your lordships have got it
I
at
have already
208.
completed paragraph 6.
Yes. Now, in terms of this, your lordships had asked how many portals are available. If your lordships will see the NIT at page 78, what is mentioned, your lordships have rightly read it in the beginning itself, page 78 at the bottom.
Page 78.
Yes, that's the invitation for the bid. At the bottom of the page, it says, note, joint ventures not allowed. The tender forms and other details can be obtained from the website arunachaltenders.gov.in. This is the only website under my instructions from the client which says in regards to PWD tenders, the tender is of the state government. We have reliance on guidelines which have been laid down by CPW to follow certain kind of a work procedure, which includes a procurement. But what the government does is normally in these kind of tenders is they flow it in Arunachal Tenders government. Any registered class 1 contractor who has to be a part of this will come to know any tender that is floated. That is the instruction that my client has. Therefore, these are all widely available in the internet. The portals that they are relying on are 3 portals. They are for procurement is one, for the NIT is another one. What the government will normally float if it is a PWD is this. So this was followed. The entire procedure in regards to this was followed. Plus, he says his qualification. Now, your lordships had asked whether he participated. No, he did not. Was he qualified for this NIT to participate? He's filed it, your lordships, in the writ appeal. The document is been
qualification at this.
okay. So
These are
the,
nice.
so the tender document that was floated was rightly floated in the Arunachal Tenders website because that's the only website to be floated. I follow the guidelines. Guidelines are established 2017 superseded by 19 and
You did
22.
not follow the way. They should have, they followed.
In fact, it is in their procedure that I have to follow.
For the state to justify.
No, I am justifying because the allegation is that the process has been not been followed. Process has been followed by the state government.
Enough.
Just a couple of minutes.
Yes.
1 minute, my lord, for one
Yes.
document. Page 203, lords, may kindly have a look. Even the department was satisfied that this was not a fair procedure. And they initially,
That the health department.
health department,
I have seen that.
yes.
Health director raised
Suspended.
objection, suspended, then PWD went ahead with the work.
My lord, lords, may kindly just 203, my lord.
Yes.
I am directed to
Which
invite a
reference?
reference to the complaint received from all Arunachal Registered Contractors Association against e-tender of Spencer, David Spencer for the project. Is enclosed here, and to inform you that the competent authority has decided to suspend the tendering process pending. disposal of the complaint. Page 203, my lord.
Page 20.
203.
Okay.
You are therefore requested to file parawise reply to the complaint and suspend the tendering process immediately till further notice from this office. These replies may be furnished to the undersigned as early as possible. Well, 2 submissions I have got. This is one. And secondly, in paragraph 15 of my writ petition, I have clearly stated that this is the only instance where they have not followed the procedure of publishing in the newspaper. And I have given, my lord, the various NITs and the press note where all were in newspaper,
Recorded.
all were in newspaper. And they have, till now, they have not justified as to why in this case, they have become so selective that no, we will not publish in the newspaper. We'll see this so that the competent persons cannot apply.
Yes. She wanted the date of the filing of the writ petition, 29th of July, 2023. Writ petition,
Well, I only wanted to participate. I never said that I should be.
the first round of writ petition.
First was by the.
The Arunachal Pradesh,
No, no,
Arunachal
I am
Pradesh
asking
registered
about his
contract,
writ petition, date of his writ petition.
21/8.
7/8/21.
Yes. After opening of all the financial as well as the technical opened on 14th of July. And this financial opened on 9th of August.
This means the order will follow.
Grateful.
Obliged.
Orders tomorrow.
Now we can wait. Deeply obliged.
Yes, why this matter is listed?
I have checked the record, Lordship. This direction has been passed, already respondent number to this present service of notice already, and this
Why this matter is listed? Huh?
ordered private respondent number to this
Service.
Lordship, actually, last occasion, respondent number 2, Lordship, the service was not completed, Lordship, but as per the record, Lordship, LSC has been appointed.
LEC.
So, Lordship,
Okay,
as LCR is already received, then paper book may be prepared, Lordship.
Okay. Matter is ready as regard service and record paperwork prepared.
Not
Paper-
there,
paper
LCR
book
only
prepared.
comes.
Huh?
That may be prepared.
Okay, record. Full stop.
Records, yes.
Legal aid council has also been engaged for respondent number 2. Full stop. Registry to prepare this paperwork and list this matter in the orders column
Yes.
again for fixing a date for hearing.
Obliged. I have received the
Matter
paper
is
book.
ready as regard record and paper.
Lordship, I am for respondent number 2.
You have received
Lordship,
paper?
I have not received paper.
First up. It is submitted by the learned counsel for the respondent number 2 that he has not received the paper book. Gelam Jimmy,
Gekenjini received.
huh?
Gekenjini.
Gelam Jimmy, you have received.
No, Lordship, paper
Received
book I haven't
along with
received.
judgment of lower court.
No, Lordship, paper book I haven't received. This
Petition
must,
copy, okay.
that must be
The
petition
learned,
copy.
LSC, legal aid counselor, has not received the paper book, which of registry to furnish the paper books to all the learned counsels for the parties and list this matter for hearing after 4 weeks.
Much obliged.
May I, my lordship? I'm representing on behalf of appellant. Here, IA number 51 of 2024 is for the criminal, is for condemnation of 121 days in connection with criminal appeal number 16 of 2024.
How many days delay?
121 days,
100?
21 days.
But it's a POXO, the respondent number 2 is not here. Otherwise, you could have condoned this delay.
Yes.
Okay, service report in respect of respondent number 2 has not yet been received. Await for service report and this matter when after 4 weeks.
Quickly obliged.
All right. Item number, please.
Yes, what is this IA?
IA lordship condemnation, sir.
Huh?
Condemnation of delay lordship.
By state,
By state lordship.
how many days?
322 days.
Lord, we have filed our objection.
Okay, where is the objection? Objection is not still in record.
Lord, my respectful submission is, although condoning the delay is a discretionary power of the
Ah.
court, but then that also has certain
Now
conditions.
tell us, this is a order, where is the judgment?
Judgment lordship, if lordship made, take lordship to the brief
But
text.
Affidavit is here.
My
affidavit.
lord, the main judgment has not been challenged. Only this is an order passed in an interlocutory application.
Please give the file.
May I take lordship to the page 83 of the writ appeal?
Page 83, read it.
Just a brief text. The pertaining to pending bills lordship, writ petition was filed lordship, the amount.
That we understand, that's why we are asking, what is wrong in this judgment?
Here lordship, here if lordship come to page 83 lordship. The payment was directed to be paid within a month of 6 months lordship. And if it's not paid within 6 months lordship, the
No.
further interest, the future interest,
So you have paid the, okay,
that was a direction lordship. Here lordship, the interest part is not there lordship. And in the writ petition lordship, if lordship see the writ petition 8 page lordship
so
16.
according to you, original direction was for payment of principal amount.
Principal amount.
And time was given that if it is not paid within this period,
Yes.
then interest at the rate something.
No, rate was not fixed.
Rate was not fixed. lordship.
Then interest.
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 Uh,
Is entitled to claiming interest lordship.
Now they are claiming interest at what rate?
Now lordship, if lordship, coming back to page 32 lordship.
Ah.
Prayer in the writ petition itself lordship.
Ah.
They sought for lordship interest at 6% interest lordship.
Hmm.
6% interest in the writ petition lordship. Which was not lordship, granted by this honorable court lordship.
Where is the original order?
Original order is at page lordship, 82 lordship. Operating portion is at page 83. Kindly see the lordship, paragraph 5 lordship. 83.
Now,
Ah.
Lordship, in the meantime, what happened, Lordship? They file on IA, Lordship.
Ah.
IA is page 84, Lordship. In IA, Lordship, they sought clarifications of, from this Honorable Court, Lordship.
Now, where is the order is passed in IA?
IA, Lordship.
After disposal of the repetition?
Yes.
That cannot be. And original order was to approach the appropriate forum for interest.
Interest.
Appropriate forum for determination of interest will not be the writ court.
Civil court law. They have already approached, it's pending before.
Now they file an IA.
Thereafter, after the suit has been filed, they have filed the IA law.
And the IA, in IA, that 10 lakh is directed.
The interest at the Lordship, relevant bank rate. Lordship.
Who calculated this interest?
It
Well,
was Lordship,
Let me explain, my lord. After this direction, we have waited for 6 months. And after the 6 months period has lapsed, the second part of the directions became operational.
Second, what is the second part of direction?
Second
Please
part
read the
is
second part of the
the-
direction.
Failure on the part of the respondent to make payment within the time frame by this court would entitle the petitioner to approach the appropriate forum for payment of further interest.
Okay, that will entitle, a right has been given you to approach an appropriate forum
Yes.
for interest
Then we have approached the
by IA.
IA no, not IA. We have filed a money shoot there.
Okay,
So during the pendency, there was some confusion because here appropriate for further interest, the word further interest, quote unquote further interest, there was some confusion. So therefore, we have filed an IA here seeking clarification on the word further interest. And on this further interest, the London single bench had clarified that it will be on the basis of the lending interest of the nationalized bank.
sorry, that cannot be. Sorry to say.
So
Supreme Court time and again said that dispose of writ petition cannot be reopened for all these purposes.
but that's
A
why
specific order was given saying that to approach appropriate forum can be reopened and given a that
No,
too in
no,
a
my lord.
proceeding.
that is my pleadings, my lord. I said they have. That's why I said, my lord, the original order has not been that not
We are
been.
condoning the delay, fixing the appeal on next Tuesday for admission. The present application is filed under section 5 of the 5 for condonation of delay filed by the state for condonation of delay of 332 days,
22 days.
322 days in preferring the connected writ appeal against judgment and order dated 9/5/2023 passed in IAC number 79 within bracket AP 2023. Full stop. The aforesaid IA was filed in a disposed of writ petition being WPC
101
WPC 101
of
2022.
WPC 101 2020 full stop. By an order dated
Lordship,
first order
996
pass order, Lordship,
96/2022.
9/6/2022. A direction was issued to the respondents for payment of certain unpaid bills. Full stop. In the penultimate paragraph of the said judgment, an observation was made that if the payment is not made during the period prescribed by the court in the said order, full stop, comma, the petitioner shall be entitled to seek interest before the appropriate forum, full stop. Accordingly, writ petition was disposed of, full stop. Subsequently, the IA was filed seeking clarification as regards the rate of interest and said and by the impugned order, further payment was directed to be made, full stop. While preparing the appeal, while explaining the delay is explained at paragraph
My lord, the paragraph 2, my lord, paragraph Your Lordship will find that totally, this is the only ground for filing the delay condonation. They're saying that they have received the order that at 9/5/2023 only on 12/12/2023. Now, my lord, even if we, my lord, first thing is, my learned friend was always there in all these hearings. And this is after 4 months. And even if, for argument's sake, we may say that, okay, they received it on 12/12/2023, but then this IA was filed on 22/4/2024. That is 4 months, 3 days. And this was moved only on 23/4/2024. This is the only reasons that they have assigned. There is no explanation of the delays.
Consider the learned counsel for the petitioner has seriously objected and submits that there is no sufficient cause to condone such delay. Full stop. We have considered the rival arguments advanced by the learned counsel for the parties. Also peruse the pleading of the parties. Full stop. The delay has been explained at paragraph 2 and 3 of the petition, connected petition. Full stop. Though delay is 322 days and day-to-day explanation has not been given, considering the matter in entirety and given the considering the explanation given and the issue involved in this writ petition, this court is of the view that the state has been able to satisfy that it was it could not approach the court within prescribed period of time in filing the connected writ appeal. Accordingly, the delay states Congress please release the connected writ appeal for admission on Tuesday. Yes, possibly. Registry to list the name of the learned counsel for the petitioner, the respondent in the cost petitions.
Obliged.
Lord, I'm sorry. In fact, Lord, they got this case listed without informing me. I don't have the brief even. It's not a
What is
fixed date.
this?
Since I don't
This
have the
is a-
brief. I don't have the brief.
Because
And
Mr.
perhaps,
Majumdar is here.
That's why,
No.
but they ought to have
Why
told
not-
me, I would have taken the brief with my hand. Possibly, that's the point, my lord. I didn't want to, I had doubts.
This is what I was.
Related matters, I think.
And
the-
possibly on couple of
counsel had
occasions,
appeared.
when the case was before the single bench, at that point of time.
Have you checked it?
I will clarify the first position first, man. My learned friend junior had an interaction with my
But
learned friend.
it is detrimental to your interest.
No, I cannot argue now. Now what has fallen
Isn't it?
from
Lord,
my
more
lord.
difficult
Justice-
is Mr.
Arguing-
Actively,
Arguing 2 matters in a day in Arunachal is
exactly,
detrimental.
that's the point, that's the point. my lord.
That is
Not
why,
good for a
No,
single
my lord.
person.
what has fallen from my honorable justice, my lord, I cannot argue. I cannot open my mouth.
No, is there anything?
No, this is what my learned friend is saying.
A distinct recollection I'm having because before signature also had appeared. on
May
my
not be
petition.
particularly in this case, but
Yes.
in
There was,
connected matters.
again, I must say with 100% certainty. I have a faint recollection that when the records of signature I was going through, at that point of time, it seems.
But I've seen it, there's nothing in this matter. which
Before
shows
writ appeal,
that
nothing.
I have
With the writ
appeared.
appeal, possibly there is nothing.
But connected
Yes,
matters,
that's
if
it.
you have any,
And some of the,
if
some
you
of
have
the,
any reservation,
no, I don't have.
No.
I will not have reservation even if my lord had appeared in some other capacity, even then I will not raise an objection.
no.
No.
In this
Even
case,
then I will
let
not.
us
then
not
if
go
you
to
don't
that
have, I
extent.
cannot.
I will not. I will not.
Now what to be done today?
My lord, I can't help it. I don't have the brief.
My lord,
with
if
me.
there is no bar like this, my lord, then I'll have to
Did I
clarify
say there
the.
is a bar? I never said. I
My-
never said.
Okay, assume there is no bar. Okay, then.
My lord, then I'll have to clarify my learned friend says he is without brief. My lord, about that, my lord, last couple of days, his junior and my junior, they were in touch. Yesterday,
will-
yesterday,
Will not,
But
will
I'm-
not
I-
hear
I
the
don't-
facts in
but
the.
slightly on the,
Hotel Riverview.
no, my lord.
Will-
No,
will-
Guwahati, my lord, Guwahati, slightly on the lighter side. My learned friend initially said that matter will not be taken up, so we are not carrying file. It's all right. Then in the evening again,
Not the sunrise. Okay.
my lord, in the evening, my learned friend says, no, I have been called up by my learned friends, my learned seniors junior, Mr. Saxena. No, the matter will be listed. We are going there, so we appear.
Mr.
This-
Sir himself is not here.
This is how, otherwise I was thinking that this.
So
matter-
give us a date.
Here, my lord, this writ appeal is against an order passed by on single judge, whereby, my lord, our prayer for grant of compensation, because these are all affected by the Subansiri project. Our only contention was that we are persons from a village called Dibe village.
Now, are we proceeding to?
No, my lord, not on merit. There are not on merit, my lord. Because there is an IA. There is
IA
an
for
IA.
what?
IA, what has happened, my lord?
No, please tell us the prayer in IA.
IA, they have filed an IA, they filed,
For?
praying for a leave to file certain documents. This is in response to some development matter that I have to tell you, Lord. The Honorable Single Judge, while dismissing the petition, my prayer was that either you grant this before some court was either compensation may be granted.
So, we are saying is, if we are not proceeding, we'll adjourn it.
No, well, there is IA may be disposed of. That's what I'm saying.
That's very difficult, because unless and until at least I should have the paper with me. Why should I comment?
Okay,
Without
we-
looking at it,
we are-
tomorrow
we are-
something happens, then I will be asked a question. Why did I do that?
His IA.
Uh,
You want
naturally.
disposal of his IA.
He's IA.
But
he
and
did
without
say-
me having the copy of
So
the
that-
IA.
so that-
Not only, he is not only without the brief, he is without the assisting counsel. Mr. Saxena is not there.
Then, my lord.
Okay, for senior
Why not?
counsel, briefing includes the assistance of juniors in many ways.
Yes.
Yes.
But
Could it be on 3rd of
those-
September? Because in any case, Mr. Dekanto Das, my esteemed colleague, would also be there. And that Mr. Mazumdar should also be available. We'll have a good company.
Yes.
Let us hope on that day his juniors are not wayward.
Even if-
As agreed to by the learned counsel for the parties,
Huh?
is this matter on 3rd of September? 3rd of September
My
or
lord,
before that?
then third is all right.
Third
Fine.
is all right.
That much inconvenience I do not want to
Yes.
cause to my friend.
3rd of
My
September.
lord, Lordship may kindly observe that on that day it will be taken up for final disposal.
See,
That I find a little bit difficult. If I am here taking my bench, I can,
All right.
but it will be.
All right.
My lord, I have not been served with the copy
Let
of
it
the.
come up for admission.
Oh, sorry, staff complete.
My lord, let it come up for admission that much.
Admission. Let's.
Because now it has come up for orders.
Admission. Pola.
My lord.
If somebody is not getting copy, who will give him copy? Referee, sir,
Respondent number 5.
copy.
That we will take. All right.
One matter. Indian on this against land acquisition matter, which is before item number 35, my lord. So, last time when the matter was taken up by this court, this indulgence was given to mention before the court. Because there is some urgency in this matter, my lord. 2018 matter. The other side is a item 38, sorry, item 38. 38. So, after the election matter, if possible,
No, we are in the midst of some part-hard matters.
yes,
Then we'll see.
yes.
But in this matter,
Huh.
also recently they have filed. So there is an instruction from my client, file the reply.
No, you have filed an affidavit, additional document, they have filed it. My lord, there is this, my lord, let this matter come up. The issue has now, no, let it come up. We'll tell the, what was the instruction was sought for to them. Now it is before the court. we are suffering is regarding about a compensation of 125 crores. And the government of India, sorry to say, they are playing with us. That's all. I'll show the affidavit. I'll show the
We'll
affidavit.
see, let us go serious.
Yes.
Wait, please, your lord.
Yes.
My lord, in item number 32 and 34.
Hmm.
The two IAs have been filed seeking amendment of the writ petition this morning.
Hmm.
My only request to your lordship is that if your lordship permits the matter to be brought on the court. It is otherwise ready,
Amendment
amendment,
filed by,
filed by the writ petitioners.
okay,
In
you are
item-
for,
Item number 32 and 34.
what is this IA about?
These, the listed IAs are different, lord, some implement petitions filed by
Okay,
some parties.
Okay,
The writ petitioners have filed two IAs today, my lord, this morning.
32 to 35. Is that-
Only 32 and 34.
Okay.
So, my lord, the IAs
Okay,
will be-
bring it, bring it.
and it may be taken up along when the matter reaches.
Give us.
Yes.
May I please, your lordship? My lord, I beg to mention item 40.
40.
40. Lordship, unfortunately, I'm not in a position to argue the matter today. And I may be out of session in the next few 2 weeks.
Okay,
So can the matter be listed on 3rd of September?
3rd of September.
Okay. Obliged.
May I, your lordship?
Yes,
Your lordship, I beg to mention item number 37, your lordship.
37.
Yes, in this matter, we were supposed to file additional affidavits, sir, your lordship. I need some more time, your lordship, for filing additional.
Okay, who is for the petition?
Lordship, Lordship, this is very old matter, Lordship. In fact, on last occasion, the government was directed to file affidavit on or before fifth,
Hmm.
and matter to be listed on 8th. I think
Yes, we have received
the instructions and
You have received
Yes,
instruction.
your lordship, for
Ah,
filing, we need
can it
some
be on,
time.
may I humbly present, Lordship, can it be on 14?
14.
Okay, lordship.
And directed them to file their
Ah.
affidavit before 14.
The learned council, state council submits that affidavit is being prepared in terms of this court's earlier order dated
25/7.
25/7/2024, however, could not be filed could not be filed before 5th of August. However, the affidavit is being filed when? Tell us.
Next week, your
Will not next week when, because he's seeking 14th. 15th is a holiday, only 16th will remain for this court, or we'll fix it on next Monday. In the meantime, next week you file this affidavit, okay?
Okay, your lordship.
By 14th of this month, 14th of August 2024, accordingly, list this matter on 19th.
Bless your lordship.
Deeply obliged.
And your lordship, also item number 19, your lordship.
19.
18, your lordship. This matter may be listed next week, your lordship.
Next week.
Yes, your lordship. 18.
19 for it.
Oblige, your lordship.
Lordship, I want to mention item number 2 here.
Item number 2.
Yes.
Yes.
Your Lordship, I am from the plaintiff.
Hmm.
I am from the plaintiff. Whereas this leading counsel is out of station on medical ground.
Okay,
So-
learned counsel for the petitioner. There is an interim order.
My lord, yes, my lord.
Praise,
Yes,
but
yes.
the notice has already been issued in this case.
The instruction was for, my lord.
Specific, some instructions were sought for
Yes.
and notice was issued in fact. Is that it?
Yes, yes.
Notice-
One interim order was passed by this honorable court.
Notice was not issued by them.
See the order, keep the file. Okay, wait, it is item number 2 only. Wait, let the other mentions be. Wait for some time.
Yes.
Can't you wait for 10-15 minutes?
Yes, yeah, Your Honor, Your Lordship, I want to mention this 36 also. Item
36. Yes, tell us.
Here,
Okay. When?
after two weeks, Your Honor.
After 2 weeks. Have it, okay, then next. Yes,
Much-
after 2 weeks.
Much-
Lordship, I like to mention item number 1 and 11, my lord.
Item number
1 and 11. And
1 and
11. The main council is out of station, my lord.
1 and
It may
11.
be listed
11
after.
cannot be adjourned. wait for some time, other councils are there, na? It is a series matter from 8. Okay. One we have adjourned.
I'm on behalf of T Tagum Standing Council, 8, 9, 10, 11 is connected matter.
8, 9, 10, 11.
I beg to mention this item because T Tagum is out of.
Okay, as agreed to by the learned council for the parties, list this matter after 2 weeks.
Much of.
8 to 11. Yes. 1, 8 to 11. Yes.
My lord, beg to mention item number 29.
Item number
29. Leading counsel is out of station.
after 2 weeks. Petitioner after 2 weeks. Yes.
Your Honor, I beg to mention item for listing tomorrow. An eviction order has been passed.
Motion.
So, motion hearing.
Motion. Yes.
Much obliged.
I may be allowed to mention item number 41, Your Worship.
Item number
41.
41. Yes.
There is a similar matter in connection to this case. So,
Okay.
so it is listed after 4 weeks. So it may be clubbed together, Your Lordship.
Okay. It is submitted by the learned counsel for the petitioner that one connected matter is not listed, which is required to be listed along with this matter.
Yes.
What is that matter?
WPC
Being
3221.
connected matter being WPC
3221.
32/2021. Full stop. Accordingly, list this matter along with WPC so and so after 4 weeks.
Much obliged.
My lord, on the first occasion, my lord, the instruction was directed to me. The petitioner's contention is that there is no allotment order in
In
favor of
favor of the
police.
police.
They were saying that only they have the sketch map, no allotment order.
Hmm.
As per instruction, we have the allotment order, my lord.
Allotment of land of department 2012, isn't it?
Yes, ma'am.
Which part?
And a serial number, my lord.
Serial number? Health Department, Community Health, PWD.
First page itself.
Huh?
The first page in the
First,
page itself in the.
what is Health Department, Community Health Center, WRD Department, PWD Department. This is first page. Second page, Patron Nigum, Housing Department, RNW, APW, Police Department, Menigo.
Yes.
Huh?
Yes, ma'am.
Mengio.
Mengio.
Yes.
Yes, Lordship,
Where your senior will be back?
yeah, after 1 week, he is on medical ground, Lordship.
After 1 week means next week.
Yes, yes.
Okay. This matter by this courts under this order dated 7/6/2024. No, 31/5/2024. Sought for certain instruction. Accordingly, instruction and notice was also issued. Notice was also issued. Full stop. All are state, Mr. You are appearing for all
Yes.
the respondents. Full stop.
Oh, the private contractor, I'm not okay.
Oh, forget about private contractor, not issue. Private contractor will execute the work in for
Yes.
you.
Yes,
Full
ma'am.
stop. Mr. Ratan has accepted notice for respondent number 1,
One,
2,
two,
3.
four.
Full stop.
4,
1, 2, 3.
3 and 4,
1, 2, 3 and 4. What about the contractor? 5.
5.
5. Full stop. 5. Let a notice be issued to the respondent. Let the steps be taken for issuance of notice to respondent number 5 also. Full stop. Extra copies be furnished to Mr. Ratan. Full stop. Steps be taken within a period of 3 weeks. Full stop. 3 days. Pursuant to this court's order dated 31/5/2024 and 7/6/2024, Mr. Ratan has produced order dated 23rd of July 2012 and a communication whereby lands were allotted to different government departments at Sagali, full stop. Serial number 11 of the said communication reflects that land measuring 4422 square meters were granted in favor of the petitioner. Police department. Such instruction was sought in the backdrop that the police department, without having any land allotment, sought to evict the petitioner. In the aforesaid background, an interim order was also filed. Full stop. An interim order was also passed. Staying order dated 21/11. Notice dated 21/11/2023, seeking eviction of the petitioner from his house. Full stop. In the aforesaid backdrop, though this court is not inclined to extend the interim order any further, however, the learned counsel for the petitioner submits that his senior is on medical leave and having some personal difficulty. So order may be passed on the next date in the presence of his senior. Full stop. Accordingly, matter stands adjourned and be listed on Monday.
Your lordship, after Tuesday to Wednesday.
Wednesday.
Yes.
We list on Wednesday. Till then, interim order passed on 31/5/2024 shall be operative.
Obliged, ma'am.
Obliged.
Mr. Ratan may also file an affidavit to bring on record the allotment order.
Yes, ma'am.
List this matter in the admission column. Yes.
Lordship, yeah, I was supposed to bring instruction also.
Hmm.
I have yet to receive the instruction.
Yes. See, what is it? Arunachal University is a creation of it must be an act statute by state legislation.
Yes.
If it is creation of state legislature, it is independent, no, not necessary. Better ends here. What instruction is required?
You'll see what I'm.
See, Arunachal University is created by virtue of an act.
Yes.
All Arunachal Pradesh University Act. So therefore, it's an independent statutory body.
No,
It is not bound under bounden duty to have the. Yes, are you having the act?
Act, Lordship.
It is volume 14.
Volume 14. Dismiss this writ petition or what?
Writ petition.
To dismiss this writ petition today itself?
Yes. Or because you're on merit, Your Lordship. Or notice, because Your Lordship, what I'm contending is that the APP SSB, that is the competent body to conduct the examination.
We understand that is competent body so far relating to the employment under state. Arunachal Pradesh itself university is a creature of a statute.
It is an autonomous body, no doubt.
So if
But
it is autonomous body, this is not binding upon.
But the APP SSB Act says it encompasses all the autonomous body also, which has been established by the state.
Where is that source?
Yes,
That cannot. We do not
that is
say.
there, Your Lordship. That is, I think, section 6, Your Lordship.
Where is the University Act? Space?
No, APP SSB Act.
APP?
SSB.
Arunachal Pradesh. Global Pradesh Protection of Arunachal Pradesh Reorganization. Which page?
Your Lordship,
Global University. It's not Global University.
let's go. Let's begin from the first page, Your Lordship. APP SSB Act.
Which page?
Madam. Sir.
Just find out the University Act here. Which page? Give the flavor.
No, Your Lordship, the APP SSB Act, the first page.
Okay.
An act to provide for constitution of Arunachal Pradesh Staff Selection Board for the purpose of conducting examinations and selection of candidates for appointments to the subordinate services, Group C posts in the government departments, organizations, and autonomous bodies, Your Lordship. Autonomous bodies established
or constituted by the state government and semi-government organizations. This is the point I'm emphasizing. Now, if we look at the section 6, subclause 4, Your Lordship, section 6, 4. Notwithstanding anything contained in any,
Section 6.
yes, section 6, point 4. Notwithstanding anything contained in any other law for the time being.
Section 6, no?
Yes,
Just
Your
a
Lordship.
minute.
6,
4, 5, 6, okay.
there's the duties and functions.
Okay.
Hmm.
Give the Arunachal Pradesh Act. Arunachal University. Where do you get it?
That I have.
Huh?
That I have one. I have one copy of that.
This.
Because in this act, Your Lordship, there is no mention of any authority given to them where they can conduct examination on their own. Now, in this case,
You are representing Arunachal. Now tell us, any procedure or any rules or any statute enacted by the university for purpose of selection of these groups? Huh?
Because it's pertaining to education department.
No. University will not be under education department. University will have, under this act, they will have a power to make rules. Or it calls it statute. And under the statute, they can proceed how to selection is to be made and not.
Your Lordship, I think it falls under the Director of Higher and Technical Education. It falls under the Director of Higher and Technical Education.
Where do you get that?
Because even the post of Vice Chancellor, it is being recruited by this office. I have one advertisement.
No. That is a different issue. Let us see how it was created. Yes, you see definition, the statutes and ordinances, regulations. They said here. We need that statute regarding selection.
There is no mention of that process in the whole act. I have one treaty, Your Lordship. So there is no whisper about that.
Yes, he should be ready.
My only.
No, automatics is, he has made an argument that the subsequent act is having an overriding effect of all other acts.
Yes.
Okay. He has an arguable point.
Correct.
But the question is whether the university can be said to be an autonomous body under the state. It is an institution created by a statute. It is not an autonomous body. That you'll have to argue. Court will not argue. From where do we get that? We are not having even the book.
No. Therefore, Lordship, I have sought instruction from the department, Lordship. On this particular point only, Lordship. So I'm yet to receive the instruction, Lordship.
Yet to receive the
Yeah,
instruction.
Lordship. Therefore, Lordship.
No, many questions will arise in view of that provision.
Therefore, Lordship.
Okay, Mr. The Learned Standing Counsel for the Arunachal Tapin, Mr. Learned Counsel, you are standing counsel?
No, I'm senior government advocate.
Okay, that's why, okay. Learned Senior Government Advocate, press for and is granted
2 weeks.
2 weeks time to obtain instruction in terms of this court's order dated 2/8/2024. Full stop. List this matter.
Your Lordship, in that case, my interim prayer may be considered
We
kindly.
continue. Yeah, list this matter on given date. After 2 weeks, given date. 28. Interim order pass earlier shall continue till then.
No, Your Lordship. I'm praying for
Adjournment. The the learned counsel for the petitioner has raised an issue that in terms of the overriding effect of ARSSB Act 2018, the selection could not have been initiated by the university itself, inasmuch as the university shall fall within the definition of an autonomous body. Full stop. Considering such argument and such requires further examination. Such argument requires further examination. Full stop. As the learned counsel for the university has sought for an adjournment, it is provided that till consideration of the aforesaid issue and till next date of listing, the university though may proceed with the in terms of the impugn advertisement dated 19/1/2024. However, no final result shall be published without leave of this court. Full stop. Without prejudice to the right of the petitioner may also participate in such selection process.
One small correction. I am not for the university.
You are for?
I'm not for the university.
You are for
I'm
the,
for the
okay,
respondent
not
who
for
want
the
to
state
take-
respondent. But we will have to issue notice then to the university.
That's fine.
Ah. উপৰত লিখিব, government so. Full stop. The university is not represented and accordingly let the notice be returnable on 28 so and so. Full stop. Petitioner to take steps for issuance of notice. You are appearing for whom?
Respondent one, chief secretary.
One. And others, how many respondents?
Two respondents.
Two respondents.
Two and-
One, but and other for 2 steps within 3 days. In the interim, episode order can episode for you.
Your Lordship, one more small prayer regarding the interim prayer. Because as your Lordship is not staying the examination of the group C post, I pray that at least the further examination skill test that may be stayed at least.
No, we are not. What will happen? Have you participated?
Yes, I'm a candidate.
No, you are participating in the selection process.
Yes,
You have filed application pursuant to the advertisement
yes, your Lordship.
in the university.
I'm a candidate of this.
You are a candidate.
Yes,
So you participate in the selection. Subject to outcome, if we say that this is no jurisdiction, we will set aside. Let the thing proceed. That will not give you any benefit.
yes, your Lordship.
If it is bad, it will be bad from initiation. If without authority they have passed. But I myself is having a serious doubt on your argument. Subject to what university says. Yes,
Oblige, your Lordship.
you participate in the selection.
Lordship. Lordship,
Where is the deputy commissioner's communication?
Deputy
Second
Commissioner.
impugn communication.
Yes. The impugn circular is at page number 45.
Now, where is that government's letter dated 23rd of July 24?
That, my lord, I have made a categorical statement that I could not get that.
Yes, who will obtain instruction?
I'm for the deputy commissioner.
Now tell us. We are taking up this matter tomorrow,
Yes, Monday.
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 See, a deputy commissioner in this case is performing a statute. What is that statute?
Arunachal Pradesh Municipal Council No Confidence Motion Rules 2000.
Okay, Act is Arunachal Pradesh Act and the
Municipal Act to take.
Municipal Act,
Act is-
Arunachal Municipal Act and
The
rules. Now he is not subordinate to anybody while performing his statutory duty. He must be clear on that. And therefore, we want to know what is the 23rd July communication 2024, on the basis of which he has stall a statutory process.
I'll come into this.
The present repetition is preferred by how many read petitioners?
6 read petitions.
By 6 read petitioners who are the councillors of which
Pasighat Municipal Council.
Pasighat Municipal Council. Full stop. They initiated a no confidence motion against the respondent number 5, who is the chief councillor of Pasighat Municipal Council. Full stop. It is the grievance of the petitioner that though the deputy commissioner, who is an ex officio, okay, the deputy commissioner, in terms of which rule?
Sub rule 1 of rule 2 of the
In terms of rule 2 within bracket 1 of rules 2015, proceeded to hold a meeting for no confidence and it fixed on 25/7/2024. However, violating the provisions of the Arunachal Pradesh Municipal Act, such process was stalled by the impugned circular dated
24th July 2020,
page
45.
Page 45. Impugned circular dated 24th of July 2024. Peruse the aforesaid circular, which suggests that the meeting has been postponed in view of a communication, in view of a letter number capital DULB/20/2024 dated Itanagar, the 23rd of July 2024. Full stop. However, it is not discernible under whose authority the aforesaid communication was issued, asking for this communication, the aforesaid letter, under whose authority the aforesaid communication was issued, which forced the deputy commissioner to stall a statutory process. Therefore, this court is of the considered opinion that the State Council shall obtain instruction and produce a communication dated 23rd July 2024 within bracket supra on the next date fixed for further consideration of the case. Please give 19th.
And on 19th, my prayer for interim may be considered.
On 19th, the prayer for interim shall be considered.
Much obliged.
Mayor, my lords.
Yes.
Lordship, I'm appearing for, on behalf of ETA. Did not come today. May I spread it, determine the list tomorrow. We will be here.
Don't do anything till tomorrow. The present writ petition is filed assailing an order of transfer dated 5/7/2024. Is that it?
Yes, ma'am.
Issued by Deputy Director of School Education, Longding
District.
Full stop. The said order is challenged on the ground that the same has been issued without any authority and in violation of Arunachal Pradesh Education Rules 2010 and Teachers Transfer and Posting Policy 2019-20, inasmuch as in ignorance of the communication of Director of Secondary Education dated 12/7/2024. Full stop. MS Mr. R. Swenso, Learned Counsel, appearing on behalf of Standing Counsel for the Education Department, submits that the Standing Counsel is having some difficulty today. Accordingly, matter may be adjourned. Full stop. Prayer stands allowed. However, till tomorrow, status quo as regard transparent posting of the petitioner shall be maintained till tomorrow.
In that case, may I pray for 12 on Monday because pay is in any case.
No. Stay, we have not passed a reasoned order. We'll have to pass a stay with a reasoned order. What is his instruction? Tomorrow. Yes.
Yes, my lord. I am for the police department. Uh, I filed this.
What
petition.
is this case about?
The case is about that. I have police have department.
Sorry, my lord, in item number 6, my lord, if my lord take up item number 7, my lord, item number 6, not necessary, my lord, taking on.
Item 7.
7, please. In 7, he is the petitioner, my lord.
Where is that order dated 6/8/2019? Mr. Tiwari, you are appearing for whom?
You know, respondent number 5.
Police department.
Respondent number 5, my lord, in fact, I'll be very brief, 2 lines. Respondent number 5 is in possession of a particular land. Now, the police department was allotted a land by the government.
Respondent number 5 is the
Is in possession of one particular piece of land, whatever. Now, police department was allotted with a plot of land. Police department, in the process of taking over possession over the plot of land, also claims possession over the petitioner's land. Petitioner's case was, look, my land doesn't fall within yours.
Okay.
Mine is separate. So the matter came before the Honorable Court. It was the respondent 5 who filed the writ petition. So matter came before the Honorable Court, and the Honorable Court directed, the order is dated 28th November 2018, page 23 to 27, Justice Salu's order. Page 23 to 27 of the paper book.
page 20.
23, the order begins, and 27 is the operative portion. Direction given was, let there be constitution of a committee. Committee will verify, physically verify, do the survey, and will give a report. Now, committee thereafter did the verification, and the report of the committee is dated 6/8/2019. The committee clearly said that my land doesn't fall within the land of the police.
Now that order is
So
challenged.
that order is challenged. In the writ jurisdiction, my lord, I wonder.
And who are you?
I am police department, my lord.
Huh?
I am
Police department.
Yes. My lord, I just want to take
Go to
you.
a civil suit.
That
My lord,
is it.
my lord, I just want to make a few submissions. My land, which was re-allotted to me. it
Police
was-
department.
Yes, it was earlier allotted to UDN housing. Then, on 31/10/2000.
No, we understand everything. Now, a court constituted a committee.
Yes, sir.
Committee gives an opinion against you.
Yes.
We'll make an observation that the parties shall be at liberty to approach the civil court. Okay? For declaration of their right, recovery of whatsoever. And the determination made by the committee shall not be binding upon the Court. This is one way. Because suppose, assuming that is a committee report, somebody will be entitled for cross-examining the committees, even if we treat it to be a report of the commissioner, which we cannot do here.
Lord, just want to appraise as to how my length has been
No,
reduced.
that we understand. Suppose we accept your story to be true. How do you accept? We'll have to just believe your story. At the same time, we'll have to believe his story also.
I have not a record to show that the chairman who was the ADC, who was chairman, had given allotment to some private individual to upon my police land, due to which my land measuring 13,75,980 was 96,000 only. Half of the land.
Problem is that the committee has came to a conclusion. This writ petition filed by the respondent that Mr. Tiwari's client ought to have been dismissed on the day one, relegating him to go to civil court. But anyway, what is happened is happened. Now we cannot proceed further.
Because, my lord, I have allotment order and revenue has also been paid 68,79,990.
Mr. Counsel, you are asking us to go through the revenue records, findings, which he has disputed.
My lord, this is the 51. One page only. The conclusion, 1, 2, 3, 4, two lines conclusion. Conclusion number 3 is in respect of the respondent file. Kipa Nikia. 1, 2, 3, 5, 4. Number 3 is Kipa Nikia.
See, this is a report by 1, 2, 3, 4. One is the DLR. We can in fact dismiss this writ petition on the basis of this writ petition. You need some time?
No, my lord, because
You don't need time.
Okay. Okay, I will, after few days, few months.
Be prepared. Hard.
Your interim order is also there, it seems. In this case, there.
Interim order,
I
what
will
in,
present after 3 days.
who is in position? Who is in position?
Position, I'm in the position. In fact, government had issued the eviction order that was also withdrawn by the government, realizing that nothing is wrong. So, I'm in the position.
The present writ petition,
Lord, interim order was granted in my favor on 2/11/2020.
what is that interim order?
Interim order is that,
Okay, we'll decide this matter. We will not keep it. Okay, argue. Argue your case. Yes. You first satisfy us that maintainability of this writ petition. One way we can accept, because it's a court monitored committee, court has directed, it has given a report, we can accept this and this writ petition. With a liberty to challenge such report before appropriate civil court with a declaration. That's all.
That's better disposed of.
That's-
Because just now I learned, Justice Tangi had seen, take the survey report also. So, I don't.
Hard. These 3 root petitions are taken up together for final disposal. Third, Mr. Lolen.
Yes.
G. Lolen, learned counsel for the petitioner. In WPC 292 AP/20 and Mr. Tiwari, learned senior counsel assisted by okay. For L. Parme. For the writ petitioner in WPC 349 within bracket AP 2020. Full stop. WPC 292 AP 2022 is filed by Director General of Police, assailing an order dated report, is it not? Is it not report? Report dated 6/8/2019 by a committee consisting of page 40.
Page may not, it start from page 57, verification report.
Order dated 6/8, order dated 6/8/2019. Order passed by the additional deputy commissioner Itanagar, Capital Complex, Itanagar. Whereby Itanagar. Such order was passed on the basis of a verification report submitted by a committee consisting of DLR and SO, ICC Itanagar, Director Town Planning, Director Urban Development, and HD is Housing Department. Urban Development and Housing Department, and under chairmanship of Deputy Commissioner Itanagar Capital Complex as chairman. Full stop. Said committee was constituted by this court under its order dated 28/11/2018, passed in WPC 592/AP 2018. This was filed by you?
Yes.
WPC 592 2018 was filed by the petitioner in WPC 349 AP 2020.
Respondent filed herein.
Namely Kipa Nikia, who is respondent in respondent number 5 in WPC 292 within bracket AP 2020. Full stop. The grievance raised in the aforesaid grievance raised in WPC 592 within bracket AP 2018 was that the petitioner is in possession of a certain plot of land in Upper Julang village near Raj Bhavan, Itanagar, which has been peacefully enjoyed by him since 1978-79. According to the petitioner, adjacent land however, the adjacent land were allotted to the police department, reallocated to the police department via reallotment/transfer order dated 31/10/2013. And in view of such redevelopment, the police department has not allowed the petitioner to develop his land, nor was he allowed to make the construction. Full stop. Accordingly, the approach this court. Police department disputed such claim of the petitioner and claimed ownership over the land wherein the petitioner was possessing. In the aforesaid backdrop, this court, under order dated 28/11/2018 within bracket Supra, directed a fresh verification to find out as to whether the land of the petitioners falls within the land that was allotted to the Urban Development Department initially, thereafter the Police Department. Full stop. The committee was constituted with additional Deputy Commissioner Itanagar as chairman. So kindly clerk see page 26, pencil, pink pencil mark. Okay. In that context, the committee verified and uh, and uh, verified and submitted the report with the following conclusions. Page 32, paragraph 11. Okay, page 32, paragraph 11. Thereafter, on the basis of the aforesaid report, the speaking order was passed by the chairman cum additional deputy commissioner, which is impugned in WC 292 AP 2020 by the police department. Full stop. Writ petition 349 AP has been filed by the respondent number 4 in WPC Swenso. The grievance of the petitioner in the writ petition raised is to the effect that where is the order of that 4 Bethel 7/12/2020, Mr. Tiwari? 7/12/2020.
14 minutes.
Page
14 minutes.
14 of your writ petition. Paragraph 14, page 14. Filed assailing a notice dated 7th of December 2020, whereby the petitioner was asked by the police department to stop and dismantle illegally constructed structure allegedly in police land. Full stop. Police land. Full stop. The verification report is challenged on different grounds, including raising dispute as regards the actual revenue record and integrity of respondent number, which is the officer you are saying he was the chairman?
ADC.
Integrity of the chairman himself. Full stop. From the writ petition, it is seen that the police department, in spite of the report filed by the committee constituted by this court, is disputing such report and claiming ownership over the plot of land. Full stop. On the other hand, the respondent number 4 in his writ petition, respondent number 5 in his writ petition is aggrieved by an order of notice of eviction. Notice of eviction. Full stop. This court, after perusal of the materials available on record, is of the view that a report has already been submitted by certain authorities constituted by this court, wherein it has been concluded that the land of the respondent number 5 does not fall under the allotted land of the police department. Full stop. In the aforesaid backdrop, it will be not permissible for this court to judicially not permissible to this court to interfere with such a conclusion on the basis of the disputed fact raised by the petitioner, police department, in exercise power of judicial review, inasmuch as to negate such report, examination of witnesses and material evidences may also be necessary. Full stop. In the aforesaid backdrop, if the petitioner, police department is still aggrieved against the report, impugn report and the order, they shall be at liberty to seek a declaration as regard ownership of their land, as well as seeking eviction of the respondent number 5 by approaching a competent civil court and not this proceeding. Full stop. In view of the aforesaid, the writ petition preferred by the police department, that is WPC 292 in bracket AP 2020, stands dismissed. Full stop. However, the police department, as observed herein above, shall be at liberty to approach the court seeking declaration of their right or recovery of recovery of possession of the disputed land, if so advised. Full stop. In the event such civil suit is filed, the civil court shall not be guided, shall not be influenced by any observation made in this writ petition or in order dated so passed in WPC so and shall deal with the subject in accordance with law on the basis of evidence and be produced by the contesting parties. Full stop. As the report suggests that petitioner is not occupying any police land, therefore the impugn notice dated so stands set aside and quashed. However, such decision shall, however, it is made clear that such decision shall not be treated as a comment on over the right title interest of the petitioner over the property, and same may be determined in the appropriate forum at appropriate stage. With the aforesaid observation, the two these petitions gets closed.
So 349 should also be closed, you know.
Huh?
WPC 349 of 2000.
In view of the order passing so, WPC 349 so stands closed. There are three petitions.
Three writ petition.
Okay.
The first one.
This
the
is
first
this is
one was
this is
92.
serial number.
My lord,
A
the one petition was disposed of by the order of the
board.
that is not on the board. It is disposed of.
No, No, we'll not say anything. We'll list this matter tomorrow and dispose it of, because without the matter being on board, nowadays we cannot
You know,
dispose.
349 is on board. 349.
349 disposed of.
Yes. Earlier was of Justice Silo, which was disposed of earlier.
No, these two repressions are disposed of, 292 and 349.
Yes, correct. That's it.
That we have disposed of. Yes.
It's a repetition 292.
Huh.
For respondent number.
Okay, give us slip. Who is appearing for whom?
Yes, yes.
Give us slip. Yes, next case.
292.
Your Lordship, I'm on behalf of my senior Nikita Dangen.
She's
She's
on
in
leave.
another court, so the matter may be passed over for some time.
Okay.
Okay.
Connected matter, item 13 minor.
Item 13.
13 minor.
Huh.
Here minor, the government has not filed the affidavit minor. Neither the standing counsel appears in my case, neither the government advocate appears in my case for the deputy one.
We'll see, we have spent substantial amount on other cases. We'll release it from the part heard.
My case may be released, my lord.
I'll release your case.
13.
Yeah, 13 will release, huh? Rest will pass orders.
My lord.
All are Nikita, others, no? Okay. We'll take up 12, 14, 15, 16, 17. 13 of future order separate, detect.
Your name.
Yeah. Yes, yes.
Not only, before my script begins, for his benefit also, one more judgment I had forgotten yesterday. I'm just referring to Shyam Prasad, this Shyam Prasad Singh versus Naval Kishore Yadav. The citation is,
Just give it.
citation is 1000, volume 8 SCC,
2000.
volume 8 SCC, page 46.
Okay.
Here, my lord, interesting observations were made and distinction was also sought to be made by the Supreme Court between disqualification and not being qualified.
That is what,
That is
what initially I was
referring to the Constitution bench, referring to the Constitution bench. So those observations, my lord, will find paragraph. I read that. I think I had given the citation.
that's a
Very well.
paragraph 16, is that it?
Paragraph 16, my lord, will find discussion. And after paragraph 16, paragraph 26, there.
Okay.
16, there is some discussion, but in my write-up, I will give the further details. regarding the
If
Constitution.
possible, this weekend.
Yes. The moment I go to
So that
Guwahati,
we carry some bags from Guwahati and we don't want to
No,
carry
but
bags
so
from here
the
also.
moment I reach Guwahati, immediately, my lord, I will
Yes,
ensure that.
yes.
There is a judgment of the High Court, I am not referring to it. It's in Panchayat case only. Therefore, should I give the citation also?
Give, whatever it is. That will at least increase our knowledge.
Yes. The single judge, practically double entry case, same Panchayat, and the court, took the same view. So that is, Lordship may have a look. I have marked it, the relevant portions. 2015, SCC online, Punjab, Haryana, 2969. The relevant portions I have marked. I have underlined, my lord. The first page I have underlined. Then thereafter, my lord will find section 11. Next page has been referred regarding disqualification. Correction of entries, all those provisions. And then disqualification, section 25. Division. Lastly, the discussion, my lord, will find, I have marked it. The internal page is not clear. The last but two.
Admittedly.
Yes, admittedly. And then, my lord, other portions, last page. That's it.
हो गया ना?
That's it, yes.
और कुछ बोलना?
Nothing, please, guys.
Yes.
So he didn't conclude. Today he has concluded. And he has taken by all those two judgments. Again, I have to look into two judgments. Very well strategized, my learned friend. No, it's okay. No, it's a lighter vein. My lord, first argument which was advanced by my learned friends was regarding 121C.
Yes.
Which I remember. 121C.
Just a minute, just. Mr. Das.
Yes, ma'am. The first argument which was advanced by my learned friend was regarding 120. We see 120. What my learned friend has argued 121C was regarding what he argued that 121C has to be read as mandatory. Then the observation came, that query came by your lordship saying that you can't read 121C as a mandatory. ABC has to be read, or you cannot like bifurcate and say that C is mandatory. Now, what his argument, 120, 1 second. 121C, what he said, that what 121C stipulates. Now, suppose, my lord, the nomination, what he said, he cannot file a nomination in a particular two place. That will amount to disqualification. Now, he is a voter in one place and he files a nomination in one place. That doesn't entitle for disqualification. My argument before your lordship is that 121A has to be read, which is most important.
Yes.
Now, second, what 121A says, my lord will kindly look into. Once again, I'm troubling with the Act of 1997.
Yes.
120A.
Yes.
His or her name appears as an page 29.
Yes.
Page 29A. His or her name appears as an elector in the electoral roll of a concerned constituency.
Yes, concerned.
Of a concerned constituency of a
Concerned.
Gram Panchayat. Ansal Samiti and Jila Parishad. Now, if you read 121A, which is an elector, you cannot have a double entry in a particular another constituency. Now, then we have to go to 108 and 109.
Okay.
Now, 108, 109, which I understand yesterday, my learned friend is saying that it's parametry a clause under the Representation of People Act.
Yes.
Namely 16 and 17. I think, my lord, that's what he was saying is a parametry clause and there is a judgment of the Supreme Court. Even if it is a double entry, it doesn't amount to disqualification. And the clause of disqualification, the grounds are enumerated below. That's what my reply to this is 120 was not before on the Representation of People Act. Because when this act was enacted, when the legislature made this law, 1997, and the Representation of People is 1950-51. So, while making the legislature making this law was very clear and they knew about 1950 and 51. So, after that, like my lord, like I put an example, DRT, surfacing. These two acts are there. Surfacing came later on, but keeping in mind, two simultaneous proceedings cannot go. One DRT, suppose the decree has been filed OA, so recovery can be made under DRT also. Surfacing also recovery can be made. But two cannot go. That is why
Let's say election, that can elect
specific
either of the.
legislation. That is why the Parliament, while making the law, was also very in mind. They knew that there is a law which has been, Parliament has made it. So they were aware of it. Even then, so both cannot go. So here is a case where your lordship will kindly see the power has given to the state list to make this particular law. So accordingly, Panchayat, under the provision of 243C, this law has been made by the state. So keeping in mind regarding about 120, 120 is never a parameter. It is a state which has made this law.
Yes,
So you cannot say that no, representation of people. That is why my lord will see it has been distinguished by the learned single judge. Babu Rao has been distinguished by the learned single judge in paragraph 33. Lordship, remember, recollected 33 is distinguished. He said that's an assembly and this is a panchayat. He also, with greatest respect, learned single judge has gone through the provision of the municipality, provision of the panchayat. That was also a worst case event. They said one is municipality is enrolled and one is panchayat is enrolled. Here is a case, in both the panchayat, your name has been enrolled. But even double entry is not permissible. So being a special law, the legislature knew about 1950-51, that is they brought this 120. So cannot say 120 doesn't have any parameter clause under the Representation of People Act. Only parameter clause is
16
108 and 109, which connect to 16 and 17. So that's what I am putting it before this court. Now,
So according to you, 120A, more particularly A and C, will give a different dimension to the whole scheme.
Because 120 was
Yes.
never before the Supreme Court,
Yes.
neither it is a part of Repetition of People Act. It has never been decided because it was never before the apex court. It was only in respect of that 16 and 17, which is 1950 and 51 of Repetition of People. That is why, while deciding the matter by the learned single judge, he has taken into account Babu Rao also and distinguished, and more categorically 120 has been spelled out. So 120 is independent and the law can be made by the state because that empowerment is
there
given
no-
under
no
the
doubt
constitution.
it.
No
Because,
doubt about
because
it.
this law is under exercise of power of 243.
Correct. That's what. That's why they made this law, knowing fully well of 1950 and 51 Act. This is my humble submission before this honorable court. Now, now, my lord will kindly see the judgment of Chera Lama case. It is based on 108. 108. But learned single judge has not taken into account only 108. He has taken into account of 120.
Yes.
Well, otherwise 108, that is why Babu Rao has been taken into consideration, distinguished, because 120 is specifically in para 33, the last operative portion of the order. If your lordship kindly look. Clearly, yes. I'll take 5-10 minutes only. That's why it's closed. I'll close it, my lord. So this is what, my lord, 1081. I made a bit of note before your lordship. I'll supply to my learned pen also. If you have not supplied to me, I'll supply. Please supply.
All books.
Yes, hearing concluded, judgment reserved.
This is. I made a detail because I just made an extempo.
that will
I made an extempo because I didn't read this.
Okay.
But all these points are being covered and being answered with my learning. Okay. So now the question is that either your lordships accept this judgment or defer this particular judgment to a larger bench.
Yes.
This is number one. Or your lordship will say, then no, there is a judgment of the Supreme Court. Supreme Court is on a higher pedestal than a High Court. So I will rely on Bapu. That's a different thing altogether. But distinguishing factor of these two particular acts.
No, even if we disagree, and because we'll have to Babura also, then also we'll have to give an answer. Babura was dealt by the
Babura has been dealt by the
dealt.
distinguished also Babura. In distinct because why? Because of 120.
Yes.
120 was never a part of repetition because paramilitary clause is 16 and 17 of 108 and 109.
Yes, okay.
I
Hearing
deeply
concluded,
oblige.
judgment
Okay.
reserved.
एक बार तुम्हारा vote देना है।
I'm sure they will give you in advance.
Seriously.
Item number 12, copying the.
13 you write down. Learned counsel for the petitioner, Mr. Rintu Saikia, submits that affidavit has not been filed in his case. Accordingly, the learned state council prays for an adjournment. Prayer is allowed. This matter be detached from the other connected matters. Where is Union of India? Union of India?
No, Lordship, I'm sorry.
Where is that? Central Government Standing Council.
Coming.
Okay, we'll conclude. We'll
Lordships.
conclude.
This is only
Huh.
a repetition of what I had
Yes.
Hearing
submitted.
part is already concluded.
Hearing concluded, judgment reserved till the delivery of judgment, the petitioner's possession should not be disturbed.
Lordship.
Mix मत करो, mix मत करो. You will start, sir. Yes.
Yes, 280, 218.
Seniority.
The list of debts, Lordship.
Yes. Okay.
Lordship, this is the W218,
WPC
218.
218. Yes. That will cover all the cases.
No, it's a bit different from 217. In the sense that in 218, the petitioner his seniority was already finalized in the year 2015.
Only dates are different, but issue is same.
No, yes, issue is same.
Issue is same.
For the
No, issue is whether they should be treated as direct recruit to put in a place in a different category or in a higher,
yes,
or they should be treated as a normal feeder cadre
yes,
to a promotional post.
Yes.
Promotion to promotional post,
yes,
and they are a feeder cadre. That is one issue, your argument. They
Yes.
are in the feeder cadre. Promotion is to the other part, and both are equally situated except the examination.
yes,
According to Mr. Tara, no. Since there is an examination, it is a direct recruit. So all judgments so far relating to the seniority between promotee and direct recruit shall be applicable.
yes,
Your is not even a case of direct recruit. It's a
Yes.
promotion, therefore that law is not applicable.
Yes.
Here. And that your conclusion is from the rule itself.
yes.
Yes. Okay.
Also, Lordship,
Mm.
the earlier rule,
Mm.
2004 rule,
Mm.
that is in the matter of consider how to specify, how to consider the seniority, that
Was not
is not there.
Mm.
So that is one point. Another thing is, Lordship, suppose it is held that they are to be recruits.
Mm.
Suppose we say they are direct recruits, the rules of seniority which are issued by the different memorandums are in place. Then also the finding in NR Parmar could not have been applied because by then this seniority, the provisional seniority was issued on 26/11/2019. NR Parmar's case was in 9/11/2019. Thereafter, the final seniority was issued in 2020. By that time, already NR Parmar's case was overruled by Mega.
judgment.
What NR Parmar said is that actually what happened is, your Lordship must have read it, the memorandum 1986, 7/2/1986. That memorandum was misread. That memorandum was misunderstood. So therefore, that judgment came to be passed. Even if we follow that memorandum perfectly, and also Megachandra said, it was said, then also the NR Parmar, in NR Parmar, that order could not have been passed. Because even if we follow that
Notification.
yes, that notification.
Which was under challenge in which were a part in NR part.
Yes, yes. That happened only because that was misread, that was misunderstood. Because what NR Parmar said is that for the year of vacancy would be the year of initiation of recruitment, which was overruled by the Megachandra case, referring to various judgments before that, saying that nobody can have a right of placement in seniority on the date before his entered into service, before he's born into service.
He's born into the.
Yeah, he's born into the cadre. So therefore, in this case, what happened is, in the case of 2018, 218, WPC 218, in 2015, his seniority position was already given in 2015. Then it was changed, and before him, the private respondents were interpolated. Before him, the private respondents were interpolated, therefore his seniority changed. In case of the other one, 217, in case of 217, this did not happen. The seniority was for the first time.
After entering into the promotional post,
Yes,
seniority was refixed.
Yes, it was fixed.
It
No,
was
no,
fixed.
in case of Larjum Doi, that is 218, after entering into the service, his seniority fixed. There is no question about it. It was changed in 2019, the provisional seniority list. But for Yamek Mije, that is the petitioner in 217, in that case, after her entry into service, for the first time, her seniority was considered by the 2019 provisional seniority list. So there is a difference here. So there is an additional ground in case of Larjum Doi.
In case of that is 539. No, this is
540.
540.
540 and 218 are similar.
Okay.
Then 217 and 9 are similar.
Okay. 540 and 218 are similar.
Yes.
And 539 and 217 are similar.
Yes. Now, Lordship.
Let us understand the facts.
Yes.
Beginning.
Yes. Lordship may take up 218. Larjum Doi.
Yes.
According to the rules.
Let us first see the rules.
Yes.
Which rule was applicable.
The rule applicable was 2004.
Where do we get that?
I have annex.
Page.
Lordship.
You have not annexed your rule in here.
No, I did.
No, in another, 217 you have. In Larjum Doi 540 minute, yes, it is not there. 217.
Can you give extra copy instead of going from here and there?
Yes.
Copy of the rule.
No, I did annex. Yeah. Yeah, मैं कम annex किया था तो. Oh, I'm sorry. I don't have an extra copy, but Lordship may take up 217 then. Because in that I have annex, yes.
Okay.
Page 25.
Page 25. I can ask her to leave for time being.
Yes.
See, you will take some time.
Yes.
Yes. 273. Yes.
Page 25.
Yes.
This is Arunachal Pradesh Secretariat Recruitment, the post of Section Officer Rule 2004. Page 25. This is 2nd June 2004.
2nd June 2004. Yes.
This is Lordship has found.
Yes.
The next page, Lordship.
Hmm.
Column 11.
Next page.
Method of recruitment, whether by direct recruitment, reputation, oblique transfer, percentage of the vacancies to be filled by various methods.
11. Okay.
Yes.
50%.
50% by promotion as prescribed at column 12. 50% by limited departmental competition exam from amongst assistants of AP Secretariat who have rendered 6 years of regular service in the grade on the basis of merit edges from the following subjects. Then Lordship may see column 12.
Now let us see column 12.
Yes, column 12. 50% by promotion from amongst assistants of AP Secretariat subordinate service who have rendered at least 6 years of regular service in the grade to the, on the basis of selection come seniority.
Now, what is this selection cum seniority?
Lordship,
What is this selection cum
there,
seniority?
there is no specific procedure given here. It's only mentioned like this.
Hmm.
So for both, it is 6 years qualifying length of service.
Hmm.
For both, they have to be assistants in the grade, in the AP secretariat. The only difference being that
One is through a regular
one
exam,
is through
other is
one is through selection come seniority promotion, then one is by giving exam on the basis of merit adjudged in that exam. So regarding the how to how to maintain the seniority between these two, it is not there in these rules. Then Lordship,
What is the rule regarding seniority under this rule? Any provision for seniority? How
No.
seniority is to be maintained?
in the in case the rules are silent on it, then it will be the length of service.
Hmm.
The Supreme Court has
No,
said
that's
that.
that's
Yes.
clear. There is nothing in this.
Yes, there is nothing in this rules. Then Lordship, the facts are like this. The petitioner was into 6/12/2013. Petitioner was promoted to the post of assistant. This is not important because assistant is a feather cadre for section officer. Then
There
on
is no dispute as regards facts that these people are not 6 years of service.
yes, there is no
There
dispute.
there is no dispute as regards that your group has got the promotion on the basis of seniority.
Yes,
There is no dispute that Tititara's client has got the promotion to the higher post on the basis of examination held. There is no dispute on that.
yes,
Therefore, only question here is whether they will be placed above you in the promoted post only for the reason that this is a direct recruit.
yes,
This is the issue.
yes, this is the issue.
Now,
Yes,
facts,
but
facts need not be recorded at all.
yes,
These are the facts, two
Yes.
facts. Yes.
the dates, Lordship.
Okay.
The dates, petitioner was, sorry, this is not the one. Petition 2013, petitioner was given a promotion as section officer. 7/11,
These are single petitioners. Okay.
one single petitioner.
No, let us.
I have given the list of deaths, Lordship.
Why not given it?
Yes.
That is there in the.
Yes, it is there. I would like to point out, Lordship, is that their advertisement
Hmm.
for the exam,
Hmm.
in case of respondents 3, 4, 5, and 6,
Hmm.
it was issued on 1st of September 2016
Hmm.
that I have annexed. Then in case of respondent number 7,
Can you give me in summary
yes,
what by whatever means who entered the promotional cadre
yes,
or maybe direct recruitment cadre, the post
yes,
where a seniority is maintained. That is, what is this called? The promoted post?
section officer,
Section officer.
yes,
Now, I want to have a list where these section officers,
yes,
there are a set of petitioners, set of respondents. Now, what is their date of entering into the service of section officer?
39, Malon.
In your all respondents, all same date?
217, Malon. Page
No, I'm not saying 217 because we are taking up the whole.
Everything is there, Malon.
Huh?
The
Which page?
Page 39
Of
of 217, the rate petition.
217
Correct.
of page 39.
Yes, page 39. Thus, there is a direct promotee. They have been maintaining rota and quota.
39, is that it?
Yes.
Okay. So can you mark it? Who are the petitioners? Who are the respondents here?
the petitioners are here.
Just a minute. Flag. Give us petitioner.
Petitioner is at serial number 37.
I'm not asking only these petitioners, all the petitioners.
On there are only two petitioners, Lordship.
No, other petitions.
Other-
These are the list, everybody's name is there.
These are
Yes,
subsequent,
yes.
Read petitions because of certain things, improvisation only.
This list is the
Final seniority list.
final.
This is
final-
the impugned final seniority list.
finality list.
Yes,
Therefore, we will have to look into the only decision is there is no dispute that you are not, you are holding the post of sectional assistant.
yes,
There is no dispute recorded herein as regards entry into the cadre.
yes,
No dispute.
yes,
Only issue is who will be senior.
yes.
Who will be senior? That is the, and what should be the principle? We will not determine who will be the senior. We
Hmm.
will determine the principle. So therefore, in this list, I want to know the position of the petitioners vis-a-vis the respondents.
What I'm showing, Lordship.
Yes.
The respondent number
Hmm.
3
Hmm.
is at serial number 27.
Respondent number,
3
okay.
is at serial number 27.
1 minute. R3.
PK Paul.
R3. Okay.
Yes.
Then.
Here Lordship may see the date.
Hmm.
8/8/2017.
Hmm.
Then next is, he's not a respondent.
Hmm.
His next one is 5/4/2013.
Hmm.
This is not a respondent, this is a promotee.
Hmm.
Then serial number 29,
29.
yes, is R2, R4, respondent 4.
R4.
Yeah, then his date of entry is shown as 8/8/2017.
Hmm.
Then thereafter, serial number 30, this is a promotee. The date is shown as 7/11.
Is he a petitioner?
No,
Okay.
that we have not come to the
Just-
petitioners yet.
Just let us identify the petitioners.
Okay,
and
okay. In that case, Lordship, serial number 31,
Hmm.
this is respondent number 5.
R5.
Yes, the date is mentioned as 8/8/2017.
Hmm.
Then respondent number 6
Hmm.
is at serial number 33.
33.
Yes. His date of entry into service is mentioned as 8/8/2017.
Hmm.
Then the last one,
Hmm.
respondent number 7. Name is entered at serial number 35. 35.
R7.
R7.
Hmm.
Bobita Chawla.
Hmm.
Date of entry, Lordship may see, it is 15/3/2019.
Okay.
Then thereafter, serial number 37
Hmm.
is the petitioner in 218.
Okay.
His date of entry is mentioned as 7/11/2013.
Hmm.
Then serial number 40
Hmm.
is the another petitioner,
Hmm.
217, the next case. Her entry of service is 12/1/2016.
Then
Yes, this is the
how many petitioners here? Two?
only two.
And other petitioners?
There are no other petitioners. There are 4 writ petitions,
Ah.
but each writ petitioner has filed 2 writ petitions. Because when the writ petition was filed, they annexed some copy, some minutes of a the minutes of a meeting recommendation basing on the Parmar's case, which was not with us. So we had to challenge it by way of filing a second petition.
Okay.
Only
Where
that.
is that second writ petition?
Second writ petition, it's
Which page will be that order?
that in that second writ petition, it is annexure 1.
Date of that recommendation.
Date of that recommendation,
Just will, for clarity, we'll just.
yes,
record it.
yes. Date of the recommendation is 11,
It was published on 24/6/2020.
yes.
And then recommendation is
Recommendation is at 11/6/2020.
prior to this,
Same.
11/6/2020.
Yes.
That is page.
In case of writ petitioner number in 218, his writ
Whoever, just give me the any page will be.
in writ petition 540, page number 16,
Page
annexure 1.
16 of 514,
Yes,
Okay.
540, 40.
540.
Yes,
Okay, we'll come to that later.
yes,
Okay. So this is the outcome of that recommendation.
yes,
So that recommendation is subsequently challenged. Initially this select list was challenged. Then when they took that this is based on the recommendation.
yes.
That is
We
that
had, we
is
had to
so more or
challenge
less
that.
same.
Yes,
Okay. Now let us straight away go to the law.
yes,
Facts is clear.
yes. Lordship, before that, I would like to point out something.
Hmm.
Lordship may
Hmm.
see, Lordship, sorry, Lordship, I got mixed up with the two files. Lordship may see page 32 of 218.
32. 218.
Yes, 218. Page 32.
Yes.
This is the list of 2015. My name appears at page 34. Page 34.
Page 32.
Page 30, starts at page 32. The seniority list. My name appears in page 34, serial number 63.
Yes.
Lordship will see just before me, mine is serial number 63. Just before me, there is one Vijay Jarang. Then Taku Rangka, Komri Nyodu and all. Now Lordship may compare this with the seniority list that was published on page 48, which your Lordship has seen earlier.
Yes, 48 meaning the 48.
At page 48, the operative portion is at page 50.
Page 50.
Yes.
So this is the, just now we have recorded this, isn't it?
Yes. Till serial number 25, 26, Lordship, in page 50. One Tabakano. Till Tabakano, Lordship, page serial number 26. All the dates are in line, Lordship. Thereafter, Lordship, the interpolation started. Just to show, Lordship. Because before this, before the seniority of 2020, in 2015, my seniority was already given. Yes, that may also be noted, Lordship.
Yes. So I will mark it in this repetition.
Yes.
List. Which was the page here?
Which one, Lordship?
That we are dealing with 540, isn't it?
Yes, we are dealing with 218.
No, now 218.
Yes.
A little ago with that the list we have seen, mark it.
It is the same list.
No, we have marked it in a different repetition.
That was in 217.
217, no?
But Lordship, it is the same here also. It is the same list is there.
No, I want my marking, no?
Yes.
That's all.
It may be.
In 218 also that page is there?
Yes, in
40.
218, page 50.
Page 50.
Yes.
Just a minute, huh? Up to 26, 19, isn't it?
Yes.
26 up to Tabakanu.
Yes.
Okay.
So with the coming of this new list, I and only few people have suffered. Other people who were in the same place as us, they've been left alone. So we are suffering because these people have entered in. So, Lordship.
Okay.
Now to the law, Lordship.
So we are taking up 2017 law.
Yes.
217 will, because you have marked it in 217.
Yeah.
Yes, law.
It is the same. So far as the law is concerned, it's same.
Law is same, yes.
Yes. NR Palmer's case, Lordship.
Yes.
NR Palmer's case, I will read only for the purpose of the OM's, Lordship.
Just a minute. Very good. Yes.
Lordship,
Paragraph?
paragraph 25, page 355.
Paragraph 35.
Yes. Or 25, 25.
25, okay. Hmm.
255. 255.
Yes.
Yes. Since it is a case of the rebel parties before us that the OM dated 7/2/1986 is the principal instruction on the basis whereof the present controversy is to be settled, the same is to be extracted herein in its entirety. Office Memorandum 7/2/1986. Subject: General principles for determination of seniority of various categories of persons employed in central services. As the Ministry of Finance are aware, etc., are aware of the general principles of determination of seniority in the central service, are contained in the annexure to the Ministry of Home Affairs dated OM number 91155-RPS dated 22/12/1959. According to para 6 of the said annexure, the relative seniority of direct recruits will be determined according to the rotation of vacancies between the direct recruits and the promotees, which will be based on the quota of vacancies reserved for direct recruitment and promotion, respectively, in the recruitment rules. In the explanation memorandum in this principle, it has been stated that a roster is required to be maintained based on the reservation of the vacancies for direct recruitment and promotion in the recruitment rules. Thus, where an appointment to a grade is to be made 50% by direct recruitment and 50% by promotion from a lower grade, the interest of direct recruits and promotees is determined 1:1 basis. Well, the above mentioned principles are working satisfactorily in the cases where direct recruitment and promotion kept pace with each other, and recruitment could also be made to the full extent of the quotas as prescribed. In cases where there was a delay in direct recruitment or promotion, where enough number of direct recruits or promoters did not become available, there was difficulty in determining seniority. In such case, the practice followed at present is that the slots meant for direct recruits and promoters which could not be filled up were left vacant, and when direct recruits or promoters became available through later examination or selections, which persons occupy the vacant slots such persons occupy the vacant slots thereby became senior to persons who were already working in the grade on regular basis. In some cases where there was a shortfall in direct recruitment in 2 or more consecutive years, this resulted in direct recruits of later years taking seniority over some of the promoters with fairly long years of service already to their credit. The matter has also come for up for consideration in various courts, cases both before the High Courts and the Supreme Court, and in several cases, the relevant judgment had brought out the inappropriateness of direct recruits of later years becoming senior to promotees with long years of service. The matter, which was also discussed in the National Council, has been engaging the attention of the government for quite some time, and it has been decided that in future, while the principle of rotation of quotas will be followed for determining the interstate seniority of direct recruits and promotees, the present practice of keeping vacant slots for being filled up by direct recruits of later years, thereby giving them unintended seniority over promotees who are already in position, would be dispensed with. Thus, if adequate number of direct recruits do not become available in any particular year, rotation of quotas for the purpose of determination would take place only to the extent of the available direct recruits and the promotees. In other words, to the extent direct recruits are not available, the promotees will be bunched together at the bottom of the seniority list below the last portion, up to which it is possible to determine seniority on the basis of rotation of quotas with reference to the actual number of direct recruits who became available. The recruitment quota vacancies would, however, be carried forward and added to the corresponding direct recruitment vacancies of the next year and to the subsequent years where necessary for taking action for direct recruitment for the total number according to usual practice. Therefore, in that year, well, seniority will be determined between direct recruits and promotees to the extent of the number of vacancies for direct recruits and promotees as determined according to the quota for that year. The additional direct recruits selected against the carried forward vacancies of the previous years would be placed en bloc below the last promotee for or direct recruits, as the case may be, in the seniority list based on the rotation of vacancies for that year. The same principle holds good in determining seniority in the event of carry forward if any of direct recruitment or promotion quota available vacancies, as the case may be in the subsequent years. Illustration, where the recruitment rules provide 50% of vacancies in the grade to be filled by promotion and 50% remaining by direct recruitment, and assuming there are 10 vacancies in the grade arising in years 1986 and 1987, and the 2 vacancies intended for direct recruitment remain unfilled in 1986, they could be filled in 1987. The seniority position of the promotees and direct recruits of these 2 years will be as under. Lordship may carefully see the illustration given. The next page. In 1986, Lordship sees P1, that is promotee, then D1, then P2, D2, then P3, D3, then thereafter P4. This is where there is the direct recruit, there is a lack of direct recruit. Thereafter, then the direct recruits are bunched together at the bottom. This is how it should be. This is the illustration that they have given. Now, Lordship, this was what was misinterpreted in this case, saying that it may take many years for departments to, after the initiation of recruitment is done, it is not the fault of the appointees if such a long period is taken. So therefore, the initiation of the year of vacancy would be the year of initiation of the recruitment. This is what was held in this case. Now, Lordship has seen this, then this was therefore
Okay, let us see the other judgment.
yes, the other judgment has mentioned this. Lordship will see judgment, Lordship, 2020, volume 5 SCC, which I have given. Lordship may see para 35. After the judgment in NR Parmar was delivered, the Union of India issued an office memorandum on 4/3/2014, defining the recruitment year to be the year of initiating the recruitment process against the vacancy year, and that the rotation of quota would continue to operate for determination of interstate seniority between direct recruitment and promotions. The memo was not made applicable to the state of Manipur till the issuance of OM dated
Which paragraph you are reading?
35
35.
in Mega Chandra's case.
Just 35. Okay. 35, no?
Yes, 35.
Yes.
May I read again?
After judgment.
Yes, after the judgment in NR Palmer's was delivered, the Union of India issued an office memorandum on 4/3/2014 defining the recruitment year to be the year of initiating the recruitment process against the vacancy year, and that the rotation of quota would continue to operate for determination of interstate seniority between direct recruits and promotees. This memo was not made applicable to the state of Manipur till the issuance of OM dated 21/12/2017, adopting the OM dated 4/3/2014 prospectively with effect from 1/1/2018. Significantly, the OM specifically stated that appointments promotions made before the issuance of this OM will not be covered by this OM. The seniority already fixed as per existing rules followed earlier in the state prior to the issue of the OM may not be reopened. It was also specifically therein that this OM will come with effect from 1/1/2018 with publication in the Gazette. From the above, it is not only apparent that the above OM was only given prospective effect from 1/1/2018, but it also contained an express acknowledgement that this was not the position prior to the issuance of the OM that and that a different rule was followed earlier in the state. The conclusion, therefore, is inevitable that at least prior to 1/1/2018, direct recruits cannot claim that the seniority should be reckoned from the date of initiation of recruitment proceedings and not from the actual appointment. Now, para 37. This is important also. When we carefully read the judgment in NR Palmer, it appears to us that the referred dated 7/2/1986, which I have read earlier, and 3/7/1986 were not properly construed in the judgment. Contrary to the eventual finding, the state two OMs had made it clear that seniority of the direct recruits would be declared only from the date of appointment and not from the date of initiation of recruitment process. But surprisingly, the judgment, while referring to the illustration given in the OM, in fact overlooks the effect of the said illustration. According to us, the illustration extracted in NR Palmer itself makes it clear that the vacancies which were intended for direct recruit in a particular year, that is 1986, which were filled in the year 1987, could be taken into consideration only in the subsequent year's seniority list, that is 1987, and not in the seniority list of 1986. In fact, this was indicated in the OMs in the two OMs dated 7/2/1986 and 3/7/1986, and that is why the government had issued the subsequent OM date on 3/3/2008 by way of clarification of the two earlier OMs. Now, Lordship will read what happened in NR Palmer's cases. In clarification of the earlier OMs in 1986, another OM was issued in 3/3/2008. That was set aside, saying that this is not a proper clarification, whereas it was actually done in a proper manner. Now, Lordship, para 39.
Yes, I have read everything.
Lordship.
Yes.
Lordship, I would like to point out, Lordship, the reason why apparently they have done this, according to them, is the memorandum, sorry. Yeah. What we have challenged subsequently, that recommendation. That recommendation.
Let us see the recommendation.
Yes.
which space? In 217, 218,
540, it's in 540.
it is in
Yes,
540.
because it was a subsequent development.
Okay.
Page 16, page 16,
16.
in 5 WPC 540. Minutes of departmental screening committee held on 11/6/2020. Lordship will see in pursuance of government order number this dated 9 June 2020, a meeting of the departmental screening committee held on 11/6/2020 at 1200 hours under the chairmanship of this, and this the members are mentioned here. To examine the representations received from section officers of direct recruits, they've simply mentioned direct recruits, and the promotees for fixation of final interest seniority under Arunachal Pradesh Civil Secretary Itanagar. Point number 2, the committee has gone through the following documents placed before the same: recruitment rules on the post-based roster, 50% post to be filled by by promotion from amongst assistant section officers having rendered 6 years continuous service in the grade on the basis of seniority, and the remaining 50% to be filled up through limited departmental competitive exam conducted by the APPSC from amongst the AS of Civil Secretariat. The existing interest seniority issued dated the existing interest seniority list issued by SID White Estate A 44 this dated 11 December 2015. Office memoranda for introduction of poster-based system issued by the administrative reforms dated 15 October 2010. Opinion of the Advocate General Arunachal Pradesh White this regarding fixation of seniority position, where he advises the government to the quota rota rule. The Supreme Court's order in the matter of Union of India versus NR Palmer. The office memorandum on interest seniority of direct recruits and promoters in structure thereof was issued by number this dated 4 March 2014. By this OM, the DOPT has examined the matter in pursuance of the Honorable Supreme Court judgment 27/11/2012 in civil appeal number
By this order was passed
yes.
on by this decision was taken on 11/6/2020.
Yes.
Already this number was overruled on
Yes,
1990.
yes, in 2019,
1990.
November 2019. What I would like to point out by reading this is, Lordship, Lordship may see page 17. What the reason they have apparently, according to them, they have done is they have said that the vacancies arose in
2012, I have read already.
Lordship,
2012, they say 2012 vacancies are
2013.
there. 2013, therefore, that should be the date of that period.
Of course,
Okay, even if assuming for a moment,
Yes.
we'll ask this to Mr. Tara. Yes,
Yeah.
you take a seat, we will reply to Mr.
Yes.
Tara. Yes, who is representing state department?
Shall I start or the government?
Okay, you lead, you support the government,
Right.
so you are the beneficiary.
Right. But
You first say the principle on the date of taking a decision to apply a principle on the basis of a Supreme Court judgment was not holding the field on that date.
for the reasons that
No, just let me complete. It was not holding on that date. And the subsequent judgment in Megachandra, it is no unambiguous term has held. Seniority cannot be claimed for a date when incumbent is yet to born in the Kedar.
even
Okay. In our considered opinion, the law on the issue is clearly declared in Jagadish Chandra Patnaik, and consequently, we disapprove the norms of assessment on inter se seniority suggested by N.R. Parmar. Okay, according to the decision of NR Parmar is overruled. However, it declared that the decision will not affect inter se seniority already based on NR Parmar and the same is protected.
that is my
I'm coming to that. This decision will apply prospectively except where initial is to be fixed under the relevant rules from the date of vacancy so and so so and so. So therefore, the prospectiveness will start clicking the clock from 19th of November 2019.
correct.
And meeting was in the 2020.
It is for the reasons that all the
Whatsoever reason,
let me
law under article constitutional scheme that is holding the appeal.
that I'll not dispute anything because in any case I have to bow down before my lord.
Yes.
Ultimately, it is my lord who is going to decide.
No, we'll go, we can decide only on the law, principle of law, not on our
Now-
whims and fancies.
Now, my lord, the promotions and the limited departmental examinations was done after the Parmar judgment. And entire process, my lord, entire process was completed on before 1911, 2019 by the Mega Chandra judgment. That's one. Now, my lord, that fortifies my argument, which my lord read. I will refer to certain documents that my lord will look into. The first, the contention that limited departmental examination.
We accept that argument for a time being.
No,
We accept that it is a direct recruit.
yes.
Let us.
No, that's why, my lord. The first contention, it goes. And it is by a latest judgment of the apex court. Just I am placing it. There is nobody to assist. Just you can help. Well, 16 straight.
Paragraph 16.
16. Additionally, a distinction has to be drawn between a normal promotion and promotion by selection through departmental examination. Promotion by selection through LDC vis-a-vis competitive examination is a facility or a chance given out of their promotion without waiting for the normal course of promotion. It in fact is selection through competitive examination within the limited examination of candidates and cannot be equated with normal promotion.
Yes, no doubt about this.
Yes, therefore law is settled. Now,
No problem on that.
yeah,
But if you read the Parmar judgment, if you read the notification, then on the specific direct recruitment, entry direct.
I'll come to that.
Yes. No, for the time being, we are accepting your argument that this is a direct case of direct recruit and promoting. Then also how Parmar is applicable can be made applicable on that date. Tell us first that.
Now, what happens is, my lord, after this particular judgment, my lord will consider one aspect of the matter. That is how the rota quota system is followed and how seniority is to be maintained. Is my lord will find kindly have read petition number 217.
217?
Yes, my lord.
217.
217.
217. Yes.
My lord, that is at page 50.
Page 50.
5th April.
50.
Yeah, 5th April 2022 notifications. At 51, my lord will.
Yes, 51.
At page 51, my lord will find the definition of direct recruits. J, clause J, my lord. Direct recruit means a person recruited on the basis of a competitive examination other than a departmental competitive examination recruited or Arunachal Pradesh Public Service Commission.
So it makes further clear.
Yes.
So your case is not a direct recruitment.
No, my lord.
See, direct recruitment means a person recruited on the basis of a competitive examination. other than a departmental competitive examination.
That is what conducted by the Public Service Commission in
Huh.
terms of the rules. So therefore, that is a direct recruitment. I'll show it from the
Yes.
record, my lord.
Yes.
Then my lord will kindly come to page 61, how seniority is to be maintained in this case.
What is this rule?
This is, my lord, this is
Secretary Service. Rule.
Secretary Service.
This rule is applicable to you.
This is applicable to us.
No, Lordship, this rule,
That's-
according to the government, it is not applicable because the rule applicable at that point of time was 2004.
Four.
Yes. 2022.
22 rule.
Now I'm relying this for quota, how rota quota has been maintained, has to be maintained
Yes.
for that purpose. Kindly come to page 61.
No, how it will, this act will help you, which is no, which act was even not born on the date of consideration.
No, I will come to that, there is another annexures which I am going to rely on.
No, Mr. Tara, we are saying that your argument is accepted. This is a direct recruitment for the time being. Even then, tell us that. Even then, let us accept this. That is a case of direct recruitment and promoting.
Yes, my lord. Therefore, my lord, kindly have this for a moment and then I'll supplement from my affidavit, my lord.
Okay.
There's seniority, how it is to be maintained, my lord, 19 page 61. 62, my lord, come. B, down below, my lord, 62B. This further clarifies in my case, my lord. B, my lord, down below, after Roman 3B. The relative seniority of direct recruits and of promotees shall be determined according to the rotation of vacancies between available direct recruits and promotees, which shall be based on quota of vacancy reserved for direct recruitment, limited departmental promotion and promotion quota respectively, the other conditions which are. My lord, kindly come to 63, my lord, for a moment.
You want to make this applicable retrospectively?
No, my lord. With this, I am going to supplement from my affidavit, my lord. That's how it was determined in this.
See,
My lord,
what we wanted is to be dot on point.
Correct. My lord, I understand.
Dot on point.
Yes.
Here issue is whether this is a direct recruitment or promoting. Number one. Number two is that even if it is direct recruit case, how Parmar can be made applicable in the speaking order when on the date the Supreme Court overruled Parmar's judgment and clarified that from this date,
Correct.
what will happen? Matter ends there.
I'll come to
That
this.
is the end of the day.
But still, if
Okay.
my lord can
Okay.
afford me 2-3 minutes,
Okay.
I have to try my luck.
Yes.
Only persuasion, my lord. Well, then this is
You also
how,
know. You also know the law. We suppose. Yes.
well, this is how P1 is promoted. LD means limited departmental, page 63, my lord. This is the how system is fixed, my lord.
Now let us see under this rule regarding limited competitive examination by the APSC. Where is that provision? What are the limited?
My lord will have this page 34 of my affidavit in opposition in WPC number 540. My affidavit in opposition. In 540, my lord.
No, this is not applicable. Very simple. Come to page 54, clause 5. See the Kedar.
79. Page, my lord.
Kedar. Cadre is from assistant section officer. The lowest grade.
But two way of entry into the section officer. One is direct.
So was that in this rule.
Here, my lord, it says, rule says, my lord, in
Which
my,
rule? Which rule?
that,
Rule of this 2022 rules.
no, 2022, it is not there. It is, I have this.
Let us
2004.
understand.
2004, my lord.
No, 2004, we are not on 2004. You are relying on 2022. So therefore, to have some relevance, show us what is the avenues and what is the method of promotion to go to all this definition of direct recruitment.
My lord is referring to which page?
No, I am referring to clause, rule 5 of page 54. Authorized cadre strength of the service.
Authorized candidates. Extent of the set. So and so there shall be, that is for section officer. Section officer is 96. Assistant section officer is 287. Percentage strength, rule shall be addition to so and so. The reserve strength shall be at level of assistant section officer.
It's totally different. These are from assistant section officer. This rule is not having any relevance in this case.
That I rely this rule only for one specific purpose. Once my lord tells that limited departmental examination through which one has promoted is nothing but a direct recruitment. So that is
That conclusion will have to come within the rule which was applicable.
Yes.
Not taking note of some other rules which came into effect on a subsequent date.
Correct. My lord. Now, my lord, the second ground which I take before I come to the law point is that final seniority list was even that, and the consequential inter-se seniority of the respondent number 3, 4, 5, and 6 in view of OM dated 8/10/2021 issued by Department of Education, Government of Arunachal Pradesh. Such a factual position, well, that kindly have my affidavit in opposition. I'm reading from here, 540.
What is your stand?
Such a factual position does not in law clothe the read petitioner with any right to challenge the assessment on merit as made by the expert committee that you duly constitute by the state government. Well, that principle Melot knows. So we need not to quarrel on that. So now that's what I was harping is, Melot. Well, 3.3, which the third ground I am taking up.
3.3 of affidavit filed in
540 below.
read it.
That the instant read petition is not maintainable in law as well as in fact, whereas the instant read petition has been filed without any cause of action and has been filed by making false claims by concealing the material facts of the case. That apart, recommendation of Departmental Screening Committee dated 11/6/2020 of seniority of direct recruits, private respondents, and the promotees petitioner in terms of OM number 20011/1/12 dated 4/4/2014 and is protected under OM number to so and so dated 13/8/2021 as notified by the authorities on the basis of the law laid down by the Honorable Apex Court in the case of Cable.
That also gone in
Yes.
view of the subsequent judgment.
Subsequent judgment. Well. So, but still, where the private respondent number 3, 4, 5, 6, and 7 case for inter-se seniority are protected, which is applicable to the Arunachal Pradesh government employee wide OAM dated 8/10/2021. So this aspect, my lord, will see. Then, my lord, only one more paragraph I'll read from my affidavit in opposition, my lord.
Paragraph?
Paragraph 5, my lord. 5. Yes. That the statement made in paragraph 2 of the read petition, your humble deponents beg to state that the private respondents who were appointed to the post of section officer in the year 2017, respondent number 4356 and 2019, respondent number 17. Having detected that their seniority were not fixed in conformity with the roster system, that is what I was referring to. How the
quota and rota.
Quota and rota. Have submitted the representation dated 10/11/2017 to the respondent authorities for fixation of interstate seniority of section officers on the basis of roster system. Date of vacancy on the ground from their date of appointment as section officer in the year 2017 against the direct liquid quota, vacancies which were occurred in 2013. But my lord, here I have to respectfully bow down before my lord.
Not bow down before, bow
law
down
is
before the
settled.
Supreme Court.
Well,
That is the decision.
No, my lord, law is
Well settled.
Well settled because even right, if like that SI Ruplal, right from SI Ruplal to this and the Mega Chandra judgment. So that way, may not kindly have this paragraph and
We have noted it down.
yes. And
That
para
is
7
concluded,
my lord,
be listed again on Tuesday for delivery of judgment.
correct.
Oblige.
Yes, take care. Item number 20, 23 and 24. What is this?
I have filed the IA matter
IA for what?
for litigation modification.
Huh?
Modification of the order matter,
Modification of interim order.
interim order matter.
What is the IA? Okay, IA. Where is the order?
Those you will find at matter page 50 matter,
Yes,
50 matter.
50.
And the relevant person is at page 52 matter. May I read, madam? Considering that prima facie the private respondent number 5 to 13 have been appointed below the rule, the impugn finance gradation list dated 22/1/2024, placing the private respondent number 5 to 13 above the petitioner shall not be given effect to. And further, and I am basically agree with this state is my lord. No further promotion be given on the basis of the impugn finance annuity list to the next higher post of statistical officer under the Department of Economic.
Any promotion process started?
Yes, my lord. And my lord, in the writ petition, they have not, my lord, mentioned anything about the recruitment rule for the next promotion post of the statistical officer. My lord.
What is the next promotion rule?
Statistical officer. My lord.
Huh?
The rule provides, my lord, 5 years of regular service in the grade, my lord. And my lord,
Their whole case is that your selection, your entry into the service differs the rule. So why should you be given seniority? You should be thrown out from the department.
yes.
That is their case.
Their case is that, my lord.
So we'll examine that.
No.
Suppose we permit you to for further promotion. What about the pleadings? State.
Affidavit government has not filed.
Yes, government.
It can be traced down, my lord.
But when file it? Your promotion was stalled by an interim order. We are fixing it on 22nd. By 19th you file affidavit.
My lord, not on 22nd, but that week I will.
29th. By 22nd, you file affidavit, 29th, we are fixing it. Simple, whether their appointment are regular and whether if their appointment is not regular, even if they are regularized, whether they can be deprived of seniority.
Yes.
These two issues. As suppose Mr. Sekia, today we permit you for promotion. Again, there, if suppose the writ petition is allowed. So we'll see on the next date.
Admittedly, to my worst, my lord, to my worst, my lord, at least, my lord.
We can
if my
even
lord-
determine this IA, we will not dispose of this IA on the basis of the affidavit filed by the state, not on the basis of your state. Do you understand? According to him, you are the beneficiary of the state. So state, what the state says, if state supports you, they can show you that this is a maybe without selection, but we have already regularized their post. They are having a right for promotion. Once they are regularized, they are in a regular cadre. All these are points will come.
Yes, sir. In fact, my lord, we were initially appointed under a scheme, my lord. Subsequently, my lord, we are regular in the year 2016. my lord. That regulation is also not put to challenge.
Regulation on which date?
On
Prior to their entry or?
Yeah, prior to their entry, my
Okay,
they were
we'll-
appointed in the year.
Okay,
2000.
let us have
Everything was
the.
done behind our back. How do I even know that they were
My
regular?
lord, they were not even born in the cadre.
No, understand? His case is that I'm being regularized, matter as there.
Yes.
My past is wiped out.
No, not like that.
Isn't it?
No, no, no.
So therefore, moment I am encadered by regulation or whatsoever, I am entitled for my promotion. This is your case.
In terms of-
So let us have an affidavit. Yes.
File karo jaldi.
The respondents have filed an IA for vacating the interim order dated,
My lord, 10/4/2024.
10/4/2024, whereby the further promotion to the post of statistical officer under Department of Economics and Statistics, Government of Arunachal Pradesh was state. It is the case of the petitioner that their services has long been regularized even prior to the entry of the, it is the case of the respondent, huh? It is the case of the respondent, private respondent, that their services were regularized prior to entry of these petitioners into service. And therefore, for all meaning and purport, they will be senior to the petitioners. And at this stage, their appointment or promotion to the further, their promotion cannot be challenged by the present respondents. Full stop.
And one thing, and one more matter, and they are not eligible for 40% of promotion. I think.
Yes,
Because they have not
it is the further case of the respondent that the petitioner has not even become eligible for the promotion to the next higher grade. Countering such argument, Mr. Panging Learned Counsel submits that even if it is assumed that they are not eligible for promotion, however, their future promotions cannot be blocked by way of the petitioners who are illegal appointees. Respondents are illegal appointees, full stop. Considering the stand taken by contradictory stance taken by the learned, taken by the petitioner and private respondents, this court directs the state to file their affidavit on or before 22nd of August 2024, full stop. Let this matter be listed on 29th for consideration, full stop. In the event, no affidavit, full stop. In the event, okay, let us do. Interim order pass earlier, shall continue. We have not closed the IA.
Obliged.
20? Yes, what is this?
25, my lord, here the state is required to file their affidavit. The issue is regarding, my lord,
Yes, what is the issue?
my lord, denial of scheduled type certificate. So in terms of the Kumari Mahuri Patil judgment, my lord, the state is required to have a committee.
Committee on.
So they have not filed. The deputy commissioner has filed, the state has not filed.
Yes, My daughter's children are now being denied scheduled trial on the allegation that my father was all along I have been a scheduled trial. Yes,
Lordship, some time may be given, your lordship, to file on behalf of respondent 1 and 2, your lordship.
if respondent number, the learned counsel for the respondent number
1 to 4, lordship.
1 to 4, prays for 10 days time to file affidavit in your
On
lord.
behalf of 4, we have already filed, your
Okay,
lordship.
respondent number 1, 2 and 3,
1 and 2, your lordship.
1 and 2. Prays for 10 days further accommodation to file.
Lordship,
affidavit
2
in
weeks,
association.
lordship.
Prayer is allowed, list this matter, give a date after 2 weeks.
Lordship.
Problem. Give a date after 2 weeks. 21st.
Not in the,
Huh?
not in the week commencing from.
29th. She gets further respite.
Obliged.
Yes. Yes.
My lord, the respondent has still yet not filed affidavit in
Yes, Rural Works Department.
RWD and Land Department.
15-16, my lordship, rural department.
My lord, RWD of course is the executive agency, monetary agency, and for the PMGSY cases, my lord, the state do not.
Who will file affidavit, tell us.
RWD, my
We
lord.
do not want history and geography.
Yes, RWD.
Who will file? R?
RWD department.
Rural Work Department.
Who is representing R?
Mr. G. Taraf.
Call him either or we'll call the commissioner and secretary to be present here
Was here.
to file
Oh,
affidavit.
he is here, he is.
The learned counsel for the Rural Works Department. We thought that we will get your commissioner here. Works Department, press for and is granted 10 days time.
But, I have not yet received instruction also, in spite of the reminders.
Then we'll call your officer. If they have failed to instruct their client, we'll have direct communication because you are the.
Sir, actually, no phone, transfer.
Okay, 2 weeks. As prayed for the learned counsel for the respondent number 4, Rural Roads Department.
Yes.
Respondent number 4? 4.
No.
2, 3, 7.
Got it. We'll write it. The learned counsel representing Rural Works Department, press for and is granted 2 weeks time. 3 weeks time to complete his instruction and file affidavit. List accordingly.
Deeply obliged.
Yes. Yes.
Malab, this is that matter, land acquisition. And whether the procedure prescribed were followed or not. And if it is followed, my repetition goes. If it is not followed, then the next course, my lord.
My lord,
Yes.
here actually what happened, my lord, this affidavit in opposition was prepared by department and only 3 days before I have received it. This must be. So I pray for a fixing a date for hearing, if it is convenient to my.
We'll hear it today.
Yes, this case is fixed after consultation with
No,
me.
yeah, that's it. That time actually what
This
is
was
right.
case for disposal.
My problem is actually what happened, my lord, 3 days back. I have not brought the case laws today. Actually, what happened, the facts of the case is this, my lord. 1962, the land was.
Oh, that are armed forces.
Yes, my lord.
Yes.
Yes.
In 1962, land was taken possession by the Union of India. Then after that, in 1972, it was acquired. And by 1972, 100% payment made. 100%.
Acquired means under what provision acquired?
My lord, 1984 Act, my lord.
What is the materials?
Yes, after that, what happened, my lord? Now, after 50 years, the petitioner is coming as a form of writ petition. After paying the all 100% amount, initially 80%, subsequently 20%.
1970, everything.
But state is taking a different.
That is because the state, that is a problem. That is the state,
No,
but they are
that-
making a major mistake.
That is not a problem.
Yes.
That is the authority to do.
No,
say.
no, no. Where state has
Suppose
committed.
you say it belongs to us, they say
Yes.
belongs to us, we will go by the revenue authority.
Yes, now what is happening over here?
Hmm.
This state government has taken possession in the name of the governor.
Hmm.
First vital mistake. This is Union of India, this order should be in.
Now, what do you propose to tell us?
So I think this will go for a full hearing, 5th of September, if it is convenient to your lordship and my lord as well. Because it will take 2
But
hours.
we'll say no further, no
Huh?
further, we'll fix on that.
Can it be on Tuesday or? No, my lord, I am outstation, and look at so only 5th of September or 6th of September as convenient to your lordship. Because in a full length, otherwise this is.
No, it will take some time, it's not.
It
that
is not the year, yes, my lord. It
take
will
some
have
time,
two
because there are
2 hours
two,
it
three
will take.
issues. To what extent we can determine, because there are all contradictory stands by the army and revenue. You have also shown that there is no procedure except issuing a notice.
Yes.
There is no procedure.
Yes.
And army says we have done it. If you have done it, show us, we'll throw him out from
yes.
the court. We'll throw him out.
Mhm.
And apparently your notification is nowhere. So one day we'll have to pay the price.
Mhm.
Might be at that point of time, barren lands.
Now subsequently, there is another.
So therefore,
developments.
you better have proper instruction.
Yes, we, 2000,
And if
that we have.
possible-
We have filed it in affidavit of opposition.
We have seen that position. That is nowhere.
Oh, now
Except
that
stating I have
document is-
taken-
That document is not with the.
And the revenue authority says, no, we don't have any.
Yes, they
directives."
don't have the documents. And
And,
subsequently.
and if we go in a proper sense, the law applicable on that day
Hmm.
was also not done, procedure not followed while taking the loan, land.
That I'll check it, my lord.
That was not
Once
done.
again, I'll check. my
That was not done. If that is not done, everything will follow. And you know, in land acquisition case, forget about 50 years, we can very well
Yes, my lord.
take.
It will be-
Law is well
There is
set.
no question of delay in this.
Yes, Mr. Dongle, learned counsel for the respondent, defense.
Can it be next 1, 3 and 4?
Next week may not be possible.
this-
Only
this-
2, 3 days.
This case was almost last time on last occasion.
No, but he was not there. What to do?
5th or 6th September, as your lordship convenient to you. Or any date of August, my
Please for an
September.
adjournment, full stop. The learned counsel for the petitioner, however, expressed serious urgency in this matter, full stop. In as much as according to him, from the record affidavit of the respondent
Number 1, 3 and
defense,
4.
as well as from the affidavit of the respondent state, it is clear that while taking over the land, private land of the petitioners, no procedure whatsoever was followed. Therefore, they are entitled for compensation in terms of the law applicable as on date.
No, my lord, prior to. No, my
So
lord.
in be that as it may, as the petitioner has expressed urgency and this matter is also pending since 2023, let this be listed on
5th of September.
5th of September 20.
Oh, finally.
This court may not grant further adjournment in this.
Yes,
case.
ma'am. 186 and 187. Obliged, my lord.
Next.
Obliged.
Yes, madam.
Lordship, private respondent are yet to appear here. Lordship.
Huh?
Private respondent are yet to appear here.
Private respondents are yet to appear
Yes.
in view of office note dated 7/8/2024. Service report in respect of respondent numbers 7 and 8 be awaited. In the meantime, the other respondents may file their affidavits.
Lordship.
Yes. Yes.
Responding number 3 yet to file the counter affidavit.
Affidavit represent filed
Oh,
by
affidavit
respondent number 2. You want to file reply, rejoinder,
No, no, my lord. Yet to file.
yet to file.
Respondent number 3.
Respondent number
We have filed, ma'am.
file. You have not received a copy.
No, my lord, I have received only 2 and 4.
Huh?
2 and 4.
2 file.
I have filed.
Who is for 4? Would you file? Huh? Okay, learned counsel for the respondent number 4. Praise for and is granted 3 weeks time to file affidavit in office. In the meantime, the petitioner may file the rejoinder to the affidavits filed by the other respondents.
Right, please, your lordship.
Yes, what is this?
My lord, it's a repetition, my lord, where certain conditions of tender has been challenged. Now, in item 32, my lord, today we have filed an application for. In item 32,
Yes. Mr. Sahala, you mute your
Speaker.
Yes.
uh,
Yes.
in item
My lord,
32.
my IA is at 43, item now
34. 34.
IA is Orion Health Burial Foods. That IA 124.
Yes, in item 32, my lord, IA is 123. That is in supplementary list, my lord, today.
I am with the 124 and 123. Yes.
Yes, these are for amendment of the writ petition, my lord. There are certain developments in the case, my lord, which we have sought to bring on record by way of amending the writ petition, certain additional facts, my lord. So that is IA 123, and in that case, it will be 124.
Yes.
So the amendment which have been sought, my lord,
And what are these other IS?
in other IS, my lord,
Other is for vacating the interim order, my lord.
Where is that?
my lord, I am coming one by one, my lord. In item 32, your
What is
lord,
the stay order? Tell us.
stay order is that, my lord, they may they may go ahead with the process.
What is the project?
This is for supply of some ready-to-eat food products to the
Pregnant
different
women.
beneficiaries under this state.
What is your challenge?
Challenge is the contradiction in the tender conditions. Now, on the interim order was that it has been operated as on date, my lord. Interim order is that they can progress with the tender process, but they will not finalize it without leave of the court. Now, state as on date, my lord, state has not sought for vacating the interim order. Now, in item number 32, your lordship will find one IA, that is 84 by 2024. That IA was filed by one party seeking an order that the interim order should be vacated. But since last date, my lord, that is 22nd of the last month, they have not been appearing, and they are not, I do not know whether or not they will.
Who is that? Who is counsel of that stay vacated? Who filed?
The counsel was Mr. D. Das, assisted by his
Mr. Das is
assistant
here.
lawyer, but they are not appearing anymore. And since last date, my lord, no one has also entered appearance in those two cases. So far as item number 3 is concerned, my lord, 33 is concerned, my lord. Item number 33 is again a tender, which is a different tender, unconnected with either item number 32 or 34. But on the last date, when it came, my lord, at my learned friend's submission, my lord, this has been put together today. But item number 33 is otherwise ready for hearing. It could
Now,
be.
what to be done today?
Now, my submission is that since that IA has been filed by us, if he does not object to, your lordship can allow the amendment.
No, that is one part, but we are worried about there is a stay of that tender process.
Well, unless the stay, the application for vacating stay is
Not necessary. Not necessary.
not praised, my lord.
Not praised, we will dismiss for default. We will see whether interim can be extended.
Yes, in that case, your lordship, I am ready for the hearing, my lord. I am ready for the hearing of the matter.
Proceed.
My lord, since my lord, now my lord, council is changed, my lord. I think my lord, for fear of justice, at least one notice has to be go to the.
Whom?
My lord,
State is not interested in vacating the stay.
my lord, we have filed the affidavit for early hearing, my lord.
Okay, let us hear it.
My lord.
Forget about other clients.
Now,
Forget about.
if your lordship will.
You argue for the client for whom you are holding the brief. That's all.
Yes.
Yes.
Now, in IA 123, if your lordship will be allowing the IA to be, the amendments to be made, in that case, my lord.
Amendment, it will take its own course. We allow, not allow, that is not relatable to the interim order. We'll see whether there is, to a such an extent that will stall or supply.
No, there is no stalling because there is.
Calling because
no,
they cannot use order.
No, there is an order passed by the government that till the time the new tender is finalized, the previous set of arrangement will continue, and that is continuing.
Who is enjoying that previous?
All, whoever were there, whoever the.
No, tell us who are there, your client?
Yes, my client
And-
as private respondents and the writ petitioner for the other
Take
side.
up this matter.
Yes,
Yes.
your lordship can then first take up item number 33. That will be 33. That will be easier to point out the discrepancy because it is otherwise ready for hearing. Your lordship may kindly see the previous
Yes,
order.
Mr. Sahil, you are for whom?
He is in item number 35.
So all are beneficiaries of the interim order. All.
No,
No,
he is not.
we are not.
He is not.
You are not. You have not filed stay vacating.
No, I'm not filed. I'm the petitioner, my lord.
He is one of the bidders in the fresh set of
Yes,
tender.
sir.
But he has also challenged the tender conditions on the ground of arbitrariness. and
All are
contradiction.
bidders, my lord. All are.
We understand. See, all are bidders. Already a system is being run.
Yes.
Some tenderers are there. They now put a challenge. There is a stay order.
My lord.
Maybe they have good ground to stay. There may be good ground to allow this petition. And in the meantime, everybody is enjoying. Okay, there may be, it's a supply.
Supply.
Supply of food to the children.
No, it is actually to the rural areas, my lord.
To the rural areas. We do not know whether rural areas people are fed or not. But there may be lower prices this year.
No,
Why is it-
actually, why the interim order was granted, the one of the consideration was that the state is also getting the supply at a much lower price because the old tender was from 2022. So state is also getting the benefit of the old price. Naturally, my lord, now the prices will rise. State is getting the supply and at the same time, the
You
system
are
is
also
also.
not a beneficiary. You are not beneficiary.
No, he is
So
coming. for
on
the
your
first
writ
time.
petition, everybody is enjoying.
No, my lord.
Except him, my lord.
Except him, everybody is enjoying.
State is also enjoying, the writ petitioners are also enjoying.
Then enjoy.
So that is the thing. But if your lordship wants to take up the matter, my lord, I'll try to place the item number 33 first.
Not necessary. You enjoy. You enjoy. IA 123 AP and 124 AP. Anybody objecting?
Malata, this amendment petition, because liberty was given to the state government to go ahead with the tender process, only not to finalize. And we have just opened a financial bid only, Malak. We have not given any work order, Malak.
That's good.
Against that, they have challenged, Malak. This
No,
amendment
I am not challenging, my lord. The word may be
That is
employed
the-
as impute. I am only saying,
development, Malak. That
I am
is the
only saying that
development.
these facts need to be brought to your lordship's notice, my lord. That is the
That
purpose.
you can file by an additional affidavit. Why should you file an amendment?
No, my lord.
If until unless prayer is.
Now, my lord, in one of the cases, my lord, they have already decided who will be the L1 bidder. That's why, my lord.
Let's see.
Your lordship may allow the amendment, my lord, and fix the matter for some other day. If they wish to file a reply, they will file it and the matter can be taken up.
123 AP, the present application is filed for amendment of writ petition WPC number 93/2024. Issue notice returnable on 22nd of August 2024. In the meantime, parties may file objection.
22nd, my lord. Can it be
Even it,
22nd of August?
yes,
22nd August.
and in 124,
The same order will follow, my lord. That is-
same order, the application amendment for WPC, just number will be set, no, same date.
My lord, in all the cases, my lord, there are interim orders and that may
So
continue.
you pass an order in main writ petition, one of the main writ petition, give the number.
My lord, in 93, 115 and 105.
You write a common order on 93, 115 and
I'm just giving it. My lord, 93, 115 and 227.
227. Okay. On the prayer of the learned council for the parties, matter stands adjourned. Please this matter on 22nd of August 2024. Interim order pass earlier shall continue till the next date of listing.
And in 115, my lord, it may come on a separate order, my lord. 115 is a separate case, my lord.
Yes, what you say?
Well, issue is same, my lord.
Issue means same tender.
No, tender is different.
Tender may be different, but issue is same, my lord.
Okay, let it remain 2 days.
My lord, there is an interim order that has to continue, my lord.
Okay, 115.
In 115.
115 separately. Huh? Same order separately 115. Well, there will be 4 orders, 2 in IA, 1 common order in 2 writ petitions, and 1 separate orders in 115.
115.
Yes.
Obliged.
Before my learned friend, my lord, as I mentioned in the morning, and
What is this?
they have filed a my lord affidavit in opposition on 24th of July, this month. And now Indian of India and army officers are also here in front of me. That is
What are these?
and actually what happens today, I have received from the instruction according to this affidavit, my lord. It is even though my learned friend is making an allegation in possession of 177 acres, but in army officer, we are in possession of only 6.
What is the issue?
I'm telling you.
No, no,
No, I'm not pressing the addition.
No.
I'm not pressing. You don't have to file. I'm not pressing. So there is no question of taking time and filing the affidavit.
Yes, that's
I'm
what
not pressing.
What is the issue?
I'll tell you. So there is no question of taking, I'm not pressing the additional affidavit. He said, I want to take time to file reply. I am not pressing the additional affidavit. I'll tell what is the case. My lord will not open the file. I'll tell what the case. Case is about in 2011. There was a in principle approval granted by the Union of India. Army wants to take possession of few land. So it is in China border. So that urgency was there. That's why they decided to take our land, which is approximately about 177 acres of land in a particular area. So now certain correspondence were made between the defense estate officer and the state. So all the formalities has to be done. So the land which we are occupying it, they want all different certificate from all the different authorities, and accordingly it was given to
Because they are worried
so
that 1950 you will acquire land, pay money, and in 2022 will again come and claim money.
Now the position of our case is different, not that case which was.
No, understand, yes.
Now, my lord, all the correspondence were done. It is on record that all the correspondence were done. Certificates given, the certificates given at different authorities, and ultimately an estimate was prepared by the state, and this estimate along with all the requisite was sent to the defense estate officer. Defense estate officer has sent to the board for giving a sanction, approval from them. That's the stage. Thereafter, my lord, the state government in 2017 had issued 3 notifications under 41 of the Land Acquisition Act, 41 through 41, and 1 under 10 of the Balipara Act. Now, in pursuance to that, under section 21 of the Lara Act, they have given a notice to all the landowners. Look here, this is a notification we given to you. Stop cultivation of the land. We will take the possession. So accordingly, in pursuance to that notice, under section 21, possession was taken by the state government, and we have been displaced. That's the position of the case. Now, thereafter, no payment has been made. However, the estimate which was prepared, 122 crores, there is no denial about it. There is no dispute about that 122.
So what was the stage of land acquisition?
Now,
first question is whether armed forces asked the deputy commissioner to go for acquisition.
I'll tell you,
If not,
I'll tell you, Lordship, what has happened thereafter. The matter came up before this honorable court, before the learned single judge. Learned single judge on the very first instance, after giving a notice and after going to the records, found that the possession is being handed over the state government. So learned single judge has passed an order stating that as it is a case of 41, it is a special case. 41 doesn't need any award. If you see 41 is prior to 43. It says prior to taking over the possession, if it is notification.
No,
under
that we
41,
understand. 41 is an emergent situation.
Emergency situation.
Emergent situation, the procedure you need not be
Need
followed.
not followed.
You can take over the position.
So now.
Now 41 issued by whom?
40 issued by the state government.
By the state.
Now I.
Now whether state has been asked to do that.
No, that I'm coming it. I'm
Yes.
coming to it. Now thereafter, my lord, what I have been done. Now on 41, the learned single are saying position has been taken over by the state. So henceforth, you are directed to pay the amount of this amount to be paid within a period of 3 months. Thereafter, the Union of India had challenged before division bench that order. Now division bench has passed an order on twofold. One fold is said that no doubt it may be a case of 41, but it appears that records has to be looked into it. Because as your lordship has pointed out, 41 speaks about an appropriate government. The appropriate government is the central government. So unless there is a direction given by the central government, so that particular aspect has to be examined by the learned single judge. One, during the course of the hearing.
So this has been returned back.
Yes. During the course of hearing, another particular question has been cropped up before division bench, which was not before the learned single judge, regarding the power of attorney which is being in the present case, which has been instituted. Whether power of attorney is maintainable under 226 in this type of case. So this matter was remanded before the learned single judge. Learned single judge has taken up the matter, not once, twice. At one point of time, learned single judge has taken the records before the Guwahati High Court, and on 2 o'clock the matter was taken and the army officer was called for. For what purpose? Now I am telling you a lot. The two aspects to be decided by the learned single judge after remand was on a power of attorney first. The learned single judge said, now I am bound by the order of the learned division bench. So first I will decide the issue of the power of attorney regarding maintainability. I argued extensively, which your lordship will find in the virtual at 2 o'clock, which you have got recorded also. Now that part is thrown judgment of the Supreme Court. Then also the power of attorney, what is power of attorney? Learned single judge was satisfied on the point, and to an extent, the learned single judge indicated the government of India, look here, this is what, and ultimately.
Was there any order?
No, there is no order as such. But you will find there.
Well, we cannot.
No value. No, whatever may be, my lord. That
No
particular
value.
one aspect of the matter.
Yes.
Second aspect of the matter was that when it was over, the learned single judge said, we want to see whether there was a sanction from the board or not. Once, twice, they this way, that way, they are having records, they were not, I don't know to what extent. The learned single judge made it very particular, we want this to see whether there is tacit approval by the board, and that will cleanse the whole issue. Now, the matter came up. Ultimately, it was again taken up by the learned single judge. Fortunately, the same learned single judge came here, and the matter was again taken up by the judge, by learned single judge. Once the matter came up, now my learned friend was not present at that time. Some adjournment was taken on behalf. He was in UK, and certain displeasure was kindly see the order that has been passed by the learned single judge. Kindly see the last order on 24/7. See this order, my lord, I am telling your lordship because this is very important.
24/7.
Yes. See the 24/7 order. 24/7. 24/7.
Yes, I've seen it.
See, lordship seen it? Now, my lord.
Just
No, please, I'll just complete it. Then you.
Only not that.
No, you.
we'll hear it.
That is.
No, what? No, why? I don't know.
What had happened?
No, what had happened, you will answer.
No, on that.
He may
order.
add 2 more lines. Just take your seat, take your seat. We are here to hear you.
Particular about that order, I am to say.
We'll just note it down.
And my lord, but prior to that order, I'll trouble your lordship with one more order of 14/6/2020.
No, that we understand. Order
No,
will
please
see.
look into that order. It's very important.
Order?
14/6/2024.
Yes.
See the order. Today on prima facie, kindly see.
Yes.
correct, my lord? Now, the board has whether your lordship has put a first question. Number one, whether under 41, appropriate government is the central government. So the court said we want to see the approval. If approval is there, end of the matter, clinches the whole issue. There has to be an approval as your lordship is
Yes,
central
yes,
government.
yes.
If approval is there, learned single express.
Because in principle, things you know,
So if
the way it is
now
well settled.
approval has to be there.
Yes.
So lordship will please
Final
keep in mind.
approval and order is to
Now,
be
now
there.
please keep in mind, 2017, there was a notification issued by three notification by the state, right? Now, after that, the government is, the learned single has said, we want to see the approval. Because if it is an appropriate government, is a central government, where is their approval? Now,
If there is no approval, then where do we see?
There also there is a point. But my case is now it's clinches. You don't, lordship has don't have to go to any other aspect no matter, because they file an affidavit where it appears that there is an approval of the court. That's end of the matter. There is no question of taking time. You cannot now turn around and say that we don't want, I'll show that.
Where is the
Where is the approval? Yes, kindly see that approval. Page 60,
Affidavit filed on?
they have filed additional affidavit filed by the Union of India. That's a big volume. That's a work. This one.
Respondent number 8 and 9.
8 and 9, no? Why not? Which is this one? 18
Yes, huh?
1 to 4. 1 to 4. 1 to 4. Let 2 days before that they have filed it. नहीं है क्या?
4th of February.
No.
6th August.
24th of July.
So it was filed on 6th of August, madam.
That is not here.
6th of August.
Not here. 6th of August, not here. You would have mentioned it, the affidavit is not here.
I mean, they have filed, they could have mentioned it. My lord, I'll just tell your lordship, kindly see. Kindly see, your lordship will bring that. That's right. Yeah, I will tell the pace. That's it. See 598. That clinches the whole issue. See 598 and date. Date कितने है तो? 2018 will fully get ordered. Now see page 598, my lord. 598. See page 598. Lordship will kindly note down date of notification is 2017. Now, my lord will kindly see 598. Board proceeding for permanent acquisition of so and so of land in so and so 598. 598, please turn to 599. Proceeds of Board of Officer assembled at on the day of 8th of February 2018 subsequent days. Lordship got it? Now kindly see. Board have assembled pursuant to so and so, so and so. Now 600 is a finding of the board. Now at page 601, it is there, my lord. My lord, it is there. It is there. 601. The board recommends that 177.673 acres of private land of so and so, comprising of so and so, at kilometers so and so, acres so and so, be acquired in order to meet the requirement of development of infrastructure of army. The board further recommends.
What happened thereafter?
No, one second. That to pay amounting to rupees 125.
No, that I have read it. My problem is this. I have read already the whole paragraph.
No. Now this particular.
I have also read the page 603 proposal. Now what happened thereafter?
Thereafter they are not paying it. Board's resolution. Now your lordship query.
Mr. Das, is the board's resolution and or Union of India who will have to ask the state for acquisition?
Already it is by acquired. It is acquired. It is acquired by them by notification. Automatically it's acquired.
No, there are two aspects of this matter. One is that suppose I am a requiring department. I have not requested the collector to go ahead with the acquisition because requiring department cannot make acquisition. It is the authority entrusted under the act to acquire. Suppose they, after this approval, this is a board decision. Union of India in Ministry of Defense says, no, we will not acquire this land. Then what happens?
They can't do it. That's the law says. They can't do it. Once you have taken a decision board and they turned down and they said we can't do it. Now my land has been taken away by the state.
No, no, your land has been taken away by the state. Seek
Maybe,
compensation from the
maybe.
state.
My lord, what was the query put forward? No, there was two.
I think we cannot decide this matter right today.
No, that is under, but see, my lord, is board.
Don't we understand? Now the matters on record. Your whole case is that the notification issued on 41 possession taken over pursuant to a board's decision. Is that it? Board decision is prior to the acquisition of the 41.
No, board decision afterwards. That's the whole case, my lord.
Yes.
So kindly appreciate, my lord. 2017, the defense estate officer prepares everything, sends it.
We understand.
My lord, your lordship has to look into that because this is a bit of all of us, your lordship has to see that.
Let's see.
No,
see. We'll see. Because time is not, we can take up this matter tomorrow also, no problem on that. See, we'll go page by page, details.
Yes.
Let us understand the fundamental concept. We'll go to detailed facts.
My lord, what I understand from your lordship's mind is that once the board has
no, it's not my mind. I am asking.
No, that's
the
what you're
board's
saying. Then
resolution,
again, board,
the board's
no, your
resolution
lordship is saying after the board resolution, again it has to go to Union of India. That's what your lordship is saying.
I'm asking whether
That's
who will pay the money.
That's ultimately the army has to
They
pay.
means who?
Army has to pay. The government has to pay.
The
Army has to pay.
Ministry of Defense will pay. Army is a wing of that.
My lord, what I'm saying, it is not my concern.
No, it's
That-
not your
That's what I'm saying. If tomorrow the boards has taken a decision or sanction,
wrong has been committed to you.
that's
That
what
we accept.
no, what I'm
But who will remedy the wrong? That is the question.
remedied by wrong by the army giving a direction to the ministry. Immediately the amount has to be deposited to the state government because we have taken a decision for approval. Now they have to take a decision. The board has taken an approval, sanction has been granted. They said, please disburse the amount. Now, if there is some certain
So according to you, moment board has taken a decision, it was a taking over under 41. So entire acquisition process is complete. Now there is no question of withdrawal of the acquisition process and only thing left is the payment of money.
Now the question, right. Now the payment, your lordship is right. Who is going to make the payment?
Yes.
That's right. I also put by a question myself. Who is going to make a payment? Because it is not the fault of us. You have taken position. Lordship is right query has been put forward. Now, because all the time, the mind.
Suppose in a given case, suppose assuming for a moment, even in a given case, on a verbal assurance under 41 a land is taken over by the collector. Whereas the requiring authority has not yet decided that we will take it loan, only that we want this loan. The authority has not yet decided. A wrong is committed to a citizen. That is correct. But whether read court in that situation, I'm not saying about
Right.
when in that situation, a read court in exercise of his power of judicial review can direct and requiring authority, no, you will have to now acquire.
Now,
It's wrong and
there are
respond.
two things.
Yes.
There are two things which I am giving an answer to it.
No,
Not your case. I'm giving an answer to it. One is that wrong has been committed. Let us understand the central government in this page, there is no sanction given. Ultimately, state has done of their own. Some correspondence was there, but the state has done a notification issued. Now today, I am sufferer.
Yes.
What will be the consequence? Whether number one,
you will have to
the
be remedied.
consequences, remedy, whether remedy is that no, state said we will not pay you. What we'll do it?
That
what
will
we'll-
decide.
no,
That will
What
decide.
we'll do it, we'll revert the land back to you. We
No,
will revert.
Reversion is whether it's permissible,
It
not
is- that
permissible.
is-
Even if reversion, damages, compensation, many
That's
things. will
all
come.
things
So
are-
therefore, that is why I'm asking the fundamental
Now fundamental,
question.
now
That whether board's resolution is the end of the road. If it is end of the road, we'll proceed on that way.
Now-
If
now
it is not
today-
end of the road and further permission from the defense ministry is required, approval is
Then-
required, then it will be a different.
No,
We'll
my
have to
lord will
see, look
see,
into.
my lord will kindly see, when the boards, that was the whole fundamental issue before the learned single judge. They said that we want to see because ultimately you have sent it to the board. Board has to take a decision. Once the board takes a decision, then
That
a
is your argument. Yeah.
tacit approval is there. Then thereafter, what your lordship has put a query, who will pay the money? The board has to put it before the defense. Defense has to make
So
the payment.
therefore,
So
boards,
it is,
boards, if you go through the board's decision, it is a proposal only.
no. I'm sorry to say.
See,
This is
see,
not a proposal.
see, page.
No.
Boards resolved that joint survey was done so and so forth,
No.
recommendation.
There are two
This is a
things.
recommendation.
No, see, please, my lord. The board recommends that so and so be acquired in order to meet the requirement
Huh.
of development of so and so.
Yes.
Further, board recommends that to pay amounting to so and so.
Now,
Till
who will accept
yesterday-
this recommendation?
Till yesterday, the position was, till they did not file the additional affidavit. They said the board has done nothing, has done nothing. Because they could not produce, they could not produce any document before the court. The court wanted to see that if it is sent to the board, by the defense asset officer, we want to see what is the board's recommendation, what is there in the board. So ultimately today, it is before the court. This is what the board has done it. It is not that.
That's why, please show us something for which we can conclude that this, though it is a recommendation, it is the final, the Union of India is bound by this recommendation.
That is what I am saying. If
See
your
page
lordship-
602, page
602.
yes,
Yes,
it is proposed that this is done
Yes.
by whom?
yes,
Financial effects, summary,
Yes.
everything is there.
findings of the board, kindly look into it. Ma'am. Now they are turning, U-turn, and they said, now this end is not required.
So therefore, paragraph 21, that's why what I am asking, what the Ministry of Defense is to say here. Who is representing Ministry of Defense? What is your stand?
We don't want to land.
Huh?
We don't want to land.
Where is your statement? File a affidavit by the secretary.
Yes, because we have never asked state government to acquire the land. It was a proposal, absolutely right, absolutely correct. It was on the proposal of some portion of the land was occupied, small portion, 6 point something acres, and land has been paying by them. And in Arunachal, in 1,025 kilometers, oh no, sorry, madam, 125 kilometers. If everybody is coming there asking, you acquire land. And due to the statutory reason, but your strategies has changes with down. Sometimes they acquire it for helipad or something like that, sometimes go to the other region because it's 125 kilometers. And that particular point, the land has been paid. So Union of India never.
Where is the affidavit of Union of India? Will not accept defense affidavit in this region. Where is the affidavit of Union of India?
They have not.
124.
That is fine.
124.
One to four.
What is your statement that Union of India do not require and affidavit filed by whom?
State officer.
Yes,
No,
madam.
officer, no madam. That cannot-
No value of that.
Actually, what is the?
No value.
Okay, if
You are saying that we have decided this proposal at the army level, defense level, and we require, ask them at paragraph 21 of that 602 page, 602 ends at paragraph 21. It says in the interest of organization. So there is no denial about the interest of interest of the organization as well as requirement of the army. Now that is not end of the matter. Now, what is the stand of the union? Let the union secretary file an affidavit.
Union
that
of
can be
India
done.
has filed an affidavit.
Where is that?
Response number 5.
No, after, what is their stand? Page? We want to know what is the call of Union of India on the
Yes.
recommendation of this board. That is what we want to know.
After they did this, because this was prior to that.
Prior, it will
Yes,
not-
board
no,
afterward, board
No,
that day,
Then we
only
can,
additional
then
affidavit
the
was-
question will arise whether Union can change their position.
They have changed it. My
No,
lord.
no, Mr. Das, you still have to make a distinction. One is defense as an organization
Yes.
and that regiment or something, and other part is the Union of India. Union of India in the Ministry of Defense.
Raksha Mantri.
Isn't it? So Ministry of Defense will, if it is also even it says that no, we are not acquiring, then also your question will remain. But if it is required,
No, this is much before that.
much before.
Actually, as your lordship understood everything. So no need to make any submission. When it goes against, he understand. When it is favored, then he'll say, I don't understand.
Because you need, at that point will be blocked.
My lord.
We need the Union of India's affidavit.
No, my lord.
It is not final that Union of India's, then only we can have a decision whether Union can take this, suppose it takes adverse, because army is with you. Defense force is with you. They said we need this land.
No,
We
they
have
doesn't-
recommended.
They doesn't want this land now.
No, now see.
Now they doesn't want this land.
Who says who
They
says?
said in the affidavit.
Whose
No, they
affidavit?
said they doesn't
Whose
want.
affidavit is this?
No, they are saying in the now additional affidavit doesn't want.
Now what
They are
happened?
they represent defense estate officer.
No,
They say
Af-
one thing.
after this recommendation, what happened?
No, they're not required. Now they are saying not required. Now they are saying not required.
That board proceeding have to go the way.
No, you have taken a decision and you sought proposal. Have you sent this
Yes,
to the union?
yes.
Then what is the stand of the union?
They don't want the land.
Where is that?
Or that Union India is not.
Where is that? Where is that?
If it takes time, I'll get it filed.
You cannot say like this.
Yes, but 2 weeks time.
Because you cannot play hot and cold by yourself.
Yes. No, I don't actually want. Now we don't want the land. State government cannot.
No, you don't want that land, we understand. But if you don't want the land on the basis of your unequivocal promise, somebody's position is reverted. Of course, your proposal is there.
And
on
that
the basis of the,
notification,
central act.
all the when we.
Forget about land acquisition. What about the compensation? Forget about land acquisition compensation. Forget what is the compensation to them. There are many aspects. Don't take it so lightly.
Section 21, once they have section 21, in section 21, a notice was given, copy they have received. In 2000, when the possession was taken, copy to them. Now they said that no, we don't.
We'll see that. What is
Yes.
their action? By whether their action it is deemed to be an acquisition. Those questions will come. But I do not think this can be decided right now in absence of the affidavit of the union.
My lord, on behalf of state government, my lord, what my friend is saying, Union of India, saying that they never demanded for land acquisition, my lord. Which is totally, absolutely wrong, my lord.
You have your document.
Yes, ma'am, we have our document. Right from the chief secretary, ma'am, they've been asking that.
That
urgently
document
required,
is-
ma'am.
My lord,
Now
today,
they are saying that
suppose,
there is no any acquisition. ma'am.
suppose
We
Union
will
of India,
examine the actions
no, suppose,
and records.
no, suppose Union of India doesn't pay it. Let us say the Union of India doesn't pay. Who pays to us? And the state government has acquired this land. Who pays to us? Now, suppose the union government say that we don't want. End of the matter. We don't want. There's a further examination by the court, whether they can say at this moment that we don't want it.
That will
That
always
is one aspect of the matter. Now, till today, from 2018, it is 2024, this person is not cultivating. Nothing, it has been handed over. So, the legislature, while making this law, made it very clear under 43 that even before an award, before possession is taken, if it is under 40, then you have to pay 80% of the total amount.
That we
Well, so now today, what has happened, my lord, we are displaced. Kindly see the problem of the petitioners.
How many petitioners?
There are about lot of more than 100, all displaced. Nothing, they doesn't have anything.
And it has been filed by whom?
Affidavit.
No, petition is filed by whom?
Pay by the power of attorney holder.
Power of attorney. That's
Power of
another question.
Power of-
Petitioners, actual landowners are in front of us.
Whatever, my lord, I argue the
Because
matter.
that's the-
If you all want to hear it, I get a project. There is absolutely no problem. I have prepared the power of attorney order, whether can they
No,
can
that we are
file
not
a
doing it
petition
for
or
that
not.
now.
The main issue is this, till today, at one point or the matter, when it remanded back to the learned single judge, because I was not appearing. For the first time I've appeared. Hereafter, it was remanded back. Then the matter came up before one of the learned single judge. I told that that's the biggest problem, that they are not paying it. Then immediately 43, while one point of time 43 was exercised by the court. But somehow, kindly see 43, my lord, for a moment see the 43 of the act. To kindly see 2013 act.
2013 Act.
Moved by the state. My lord, one, I am asking myself, hey, to take this. I am asking myself whether there is a denial by number one state, neither there is denial by the Union of India. It is not a case under 40. Not a case under 40. Kindly see 40, my lord. 43, kindly see. 43, my lord. Before taking possession of any land under subsection 1 or subsection 2,
It's chapter 6.
Chapter 6. Chapter 5, chapters, it will be chapter 5. Chapter Rehabilitation Resettlement Award.
Resettlement,
Chapter 5. Rehabilitation Resettlement Award.
reasonable. Section.
If you see at 40,
41,
3, 40, 43. 43, subclause 3.
Subclause 3, 40
Yes.
subclause 3.
Yes.
Okay.
40.
Yes.
Before taking possession of any land under subsection 1 or subsection 2, collector shall tender payment of 80% of the compensation for such land estimated by him to the person interested entitled thereto.
Where is the notification?
Yes. Kindly see the notification is at page.
Any communication prior to the notification that we want urgently?
Yes, it starts from page 99. Notification C file 99. 99 is the notification. There are 3 notifications, 99. Now, sir, where it appears is that your lordship got it
Yes.
in schedule below for so and
This is
so.
41.
41, yes, 41. This is 130 acres at the page 100. Now, the next notification is 41, another 102. The 102, next notification. 102. 40, 41. Next, 102. And the third is 105. This is under section 10 of the Balipara Act.
Now, why Balipara?
They have issued as Balipara Act.
If it is.
But it is for different. For any act, my lord, if it is under a Balipara Act also, if
No,
any.
that we understand, but they have not initiated with Balipara. They have started with
Right.
13. Then
But-
how Balipara will
But
come
if you
later
see the
on?
second line, whereas the government of
Space,
Arunachal is
space.
satisfied land mention is needed for defense purpose.
Space.
Page 105.
Yes, 105.
Second paragraph. Whereas the government of Arunachal is satisfied land mentioned in the schedule below is needed for defense purpose. It is hereby rectified land in local district is needed for the above purpose. It is for is a defense purpose.
Now we want to know states, where is the state's affidavit?
State, yes. State affidavit is. So, Fourteen. State affidavit, state government's affidavit.
Withdraw power of withdraw. States affidavit. Respondent number state.
5. I only gave it.
8 and 9, madam.
8 and 9, 8 and 9.
That is 8 and 9. So not even properly written.
My lord, I have supplied my document.
Because when I say see, where is the affidavit? Why they keep the affidavit separately? Respondent 8 and 9, yes, tell us.
My lord will kindly see paragraph 8. Nancy agrees the matter necessary directed to stop all kind of activities or villager stop all type of so and so. On expiry of CPL 45 days course again all land.
No, what we want is, they have issued notice under 40,
Yes.
41, 42. Now, on the basis of what instruction they have issued that notice? Anything on the statement, your statement? Where is the requiring authorities request to you that we want this plot of land, please initiate the process of acquisition? Because a procedure is to be followed.
My lord.
We understand there is a survey, joint survey, this, that, what not. But to acquire a land, the requiring authority is to request the collector that we require this much of land for defense estates. We want that to be required. Then only notice will be issued.
Yes, my lord, there is a requisition.
Where is that?
My lord, if your lordship see, my lord, the government affidavit 8 and 9, page 15, my lord. Annexure 3, my lord.
Page 15.
1-5, yes, my lord. It's a acquisition of 200 acres of land at Chaklagam Circle, Anjo district.
Page 15.
Page 1-5, my lord.
Yeah.
Annexure 3. Address to the, my lord, additional deputy commissioner. Subject is, my lord, acquisition of 200 acres of land.
Page
1-5, my lord, 1-5.
of affidavit of respondent number 8 and 9.
Yes, my lord.
Tanato 2.
It's filed by.
There is one respondent 8 and 9 by Tanato 2. Is it 40 years? Tanatagi?
No, Malaysia, Rupir Sibab. Rupir Sibab.
Who is he?
Malaysia Circle official, my lord. This was filed on 14 November 2022.
Here paragraph 15 is a certificate. Dr. Tojum Tete.
No, my lord, that's different.
Acquisition of Indian Army.
I lord, can I have my copy, my
Affidavit filed by which respondent?
lord? Filed by 8 and 9.
Huh?
8 and 9.
8 and 9. Sri Tanuto 2.
It seems that there are two affidavits, my lord. My second colleague is referring to affidavit filed by one Dr. Sibo.
Yes.
No affidavit is there. Please complete the record first.
One is
What is your record? Acquisition record? And Army, where is the record regarding this project? Admittedly, there are some process.
Yes.
Admittedly, there was a recommendation, there was a decision. We want the record of this. All this. Yes, where is the record?
When, without our President of Union of India, notification was issued, then immediately Union of India instructed to withdraw all notification and not to do henceforth. But that is I have stated in my affidavit.
Your statement will not do.
No, not
We
my
want-
statement. I have given I have annexed the letters. I have, that's not my
Huh?
statement.
No
I annexed
affidavit is
letters.
there.
My lord, we
Mr. Das, do you understand?
No,
the
I
issue?
understand. No, what my learned friend is saying, that we decided to withdraw it. My lord-
Decided to withdraw by whom?
No, but no, kindly see, 17 if 2017 is a notification, then immediately they should have written why they have taken a boards, because they were not pressing it before the court. Today, whatever may this way, that way, there is a recommendation given by the board.
No, that's correct.
That's a recommendation.
That
Today,
there
they
is no
cannot-
denial of this fact. See,
So now, my lord, what to do thereafter, after recommendation? But they can't say that there is no recommendation about till yesterday.
there is
Till yesterday, they were saying there is no recommendation of the board. That's the whole
recommendation is
problem.
there. Now the second question is, the 41 notice were issued prior to the recommendation. Even if we say that recommendation is there, so it's that it is relatable to maybe subsequent, but it's ex post facto approval.
Yes.
That we can understand. But issue, according to me, subject to deliberation, is who are the authorized person to ask the deputy commissioner or say collector to acquire a land. This is one. If a person without authority has requested the deputy commissioner and deputy commissioner acted on the basis of such authority, whether it can be said to be a land acquisition process. This is one. Second, even if it is not held to be a land acquisition process, no, you should not, you are an officer. Where? Even if it is said that the find the land acquisition process was not in the acquisition process in the eye of law, you cannot be remediless. That is another aspect. But before you go to the second point, if we held that it is a principle of doctrine of relation back, that their approval is there or not, then of course it will be as determined as a compensation. But we want to know under what authority deputy commissioner has issued the notice 41 and whether some discussion between some state officers and deputy commissioner and some decision thereon can be a valid acquisition process.
But today also, after post facto approval, recommendation, its fact it was there after the notification of 2017, even then there was a recommendation. It was placed
now
before
we'll
the
have to
board.
satisfy this court that this is the final board, nothing more. Board's decision is the final.
Now it is, see, one, the boards has secondary decision regarding they have proposed or they have recommended. It is now the board who will do further. Board has to do further.
Yes.
They cannot now, what they are saying is, even there is a board who will take a decision. Now they are taking a somersault saying that no, now it is not required. This is the whole problem. They will not send it, it is not required.
Suppose we say that this board's decision to say not required is not sustainable in law because of the deliberate discussion, decision. For a moment, we say, what next?
The next is that whoever has rightly, wrongly acquisition, they have to pay us compensation.
No. Then the Union of India will have to approve with their proposal.
No, that is why I'm saying that is one aspect of the matter. One is that once you...
Because suppose we pay, you pay. Pay from whom? We'll have to give specific.
Right.
Second thing, we cannot say that you will have to acquire the land. We cannot say that because it is prima facie in the stage of proposal and recommendation. It has not seen the day.
Now one matter has gone to the...
Now whether promissory
similar matter has gone to Supreme Court, on the matter, because there are a number of cases which has gone to Supreme Court. In that case also, there was sanction was not there. Now by the time it is taken away, it is on lease. Now the apex court has said, no, you grant sanction. You grant sanction.
Of course, we are not saying we are
sanction.
We are not saying that we are not powerless, but yes, situation is that what is the stage? That is very important. Union's office, defense officer is nobody for that decision.
No, if defense estate officer is doesn't have anything, then why there is a correspondent between defense and estate? Send all the copies to them. Why it is sent to the board? If defense estate, they should have written to the defense, don't proceed. Why they have done?
They have on principle has allowed the defense estate officer to carry on.
They carry on.
See, Mr. Das, carrying on action, direction of somebody, we are in a courts of law.
I know, your lordship is under court of law. Your lordship has lot of restriction.
Yes.
I know
Because,
that there are a lot of
because
restrictions.
judicial review will have to have a satisfaction that yes, it was done in a manner prescribed under law.
No, two things are there. If your lordship finds under 41, it who is the appropriate authority, appropriate government is central government, number one. Number two, whether central government has given a direction to the state government for issuing a notification. This is number two. Number three, now all the correspondence were sent, but it has gone to a stage where only a proposal they decided that we decide after 2017, after issuance of notification, we decide yes, we decide that propose to acquire that land and pay that amount. Now, next question which comes, what happens next?
What happens?
What happens next? Whether by virtue of that, automatically deem that they should have sent it to the external ministry. Yes, we have board, there is a board who has taken a decision. Now is a mere formality that you have to sanction it. You have to accept that resolution of the board because there is a board. Which board will formulate?
100 because of land in terms
177
of the
acres.
executive rule of executive business.
Yes.
You will have to go to the defense minister, not anybody else.
Now, there is one circular, which that's we have got one circular. Now there is, I don't know whether a copy is there. I think we have given one copy.
So many papers, but no sequence. Just tell us you read it.
Yes, I'll just read this.
Just read it slowly.
This is Directorate General Defense Estate. Defense Estate Department is a nodal agency for acquisition of land for service and other defense establishment. That is Army, Navy, Air Force, DRDO and others. After in principle approval is given by Ministry of Defense. Here in principle approval in 2011 it was given on record. For a particular project involving acquisition of land, a board of officers is convened by local military authority for formulating the proposal. The board of officers is advised by the defense asset officer on the cost of land and asset as well as rehabilitation, resettlement aspect. Ministry of Defense issues sanctions for acquisition on the basis of the recommendation of the Defense Estate Department. On receipt of government sanction, DO place demands upon DC competent authority for acquisition of land. He liaises with the land acquisition collector, state government to expedite publication of statutory notification under the relevant Land Acquisition Act. DO is involved in the proceeding under section 9 and 11 of this act. Analyze and appropriate recommendations are made to the government in this 9 and 11 of this act. Analyze and appropriate 9 and 11 of this act and justify the basis for the rate adopted by government in respect of proposed acquisition. Draft award as prepared by collector is proceeding are defended by DO on behalf of government to expedite land acquisition. On declaration of award under the relevant act, DO deposit compensation amount with the competent authority, takes over the acquired land and hands it over to the user service. DO also make necessary entries in military land registry and Raksha Bhumi database. All litigation arising out of land acquisition handled by DO on behalf of the government from lowest to the apex court. Payments on accounts of compensation as per decree of the court at various rehabilitation and resettlement proposal for project affected families are examined and processed by DEO for government sanction. So now it is, if it is a case under 9 and 11, this is not a case under 9 and 11. It is a case under 40. So there are certain procedures.
We understand.
Under
40 and 41 is
now
an
your
urgent
logic,
basis.
I am also putting a question. See, we are assisting court. It is not that 125 crores. There your lordship is sitting and deciding a judicial particular. Your lordship has examined this particular issue. What I'm on and what your lordship anxiety is regarding 40 and 1. Now a notification issued by the state government, undoubtedly there is no
No doubt about it.
doubt about it. Now, whether that notification is on the advice or on the note given by the appropriate government, namely the central government,
Yes.
which apparently they are saying that there is no sanction or there is no direction
See,
given
one
by.
another aspect of matter is the 2011 is the principal approval. Then it proceeds to the defense state. Now, after defense state, it again goes back to the Ministry of Defense for final approval.
Right.
When final approval is given, then money is sanctioned and all. Here what happened is, even if in 41, if there is urgency, if any, there will be some notification, separate notification, we do not know. If you can get hold of it, that can give you a handle. Here is also, there is a principle, on principle approval. But final approval is not there till now.
No, that is why when
Now,
the
on what basis
on final
the notification process is already started? You clarify this, everything will fall. That's all.
No, what the court was of the view. The court was of the view that in principle approval may be there, but we want ultimately there is a board who will take a decision.
Now, board will take a
boards-
decision.
Now
Board will take a decision
Now,
and
they said-
recommend it to
no,
the
that,
ministry.
till that day yesterday, there was no board's meeting before the
No,
court.
that is a different issue,
No,
but now
that's-
it is on record.
No, now it's on record that there is some proposal.
Until
being
and
proposed.
unless you file
2000
until and unless you file a reply and say that this is a manufactured document.
No, that I can't say. How can I? We are saying that's right. No, we will say that what we are saying 2017, there is a notification issued for acquiring that land. Then thereafter 21 notice was given. This government is saying, the Union of India is saying, no, where is that? We don't know about, the state has issued that. If that be the case, why in 2018? My question is, why in 2018? That is 5/3/2018, why it was placed before the board? It should not have been placed before the board.
Yes.
If you have taken a decision and if you are saying that that particular, there is no question of acquiring by the government under 41, then if that be the case, that would be the end of the matter. If when 21 notice was
You have to
issued,
say that some affidavit, there is a request for acquisition under 41. Where is that?
My lord will demonstrate that, my lord.
no, I'll just complete this. If 21, that notice was issued by the state government and they say stop cultivation, that copy was given to defense estate officer. Now, when the copy was given to defense estate, now let us for an argument say defense officer, state officer has kept them. He has not sent it. Let us say that they are not aware of it. If that be the case, my question is that why it was placed before the board and on 5/3/2018, the board should have said, we will not go ahead. That is the end of the matter. Why the board has taken that decision to recommend,
No, that's
proposed.
correct. Correct.
So that means they have taken.
See, it
No,
should ultimately end the aid of the, these are the sub-clans.
Yes.
Since you are in Arunachal, you are saying clans. See, these are sub-clans. The fundamental root is the final approval by the Ministry of Defense. So therefore, we accept everything that yes, defense state wanted to acquire this land. The board recommended and board and defense state proceeded on the basis of the in principle approval. Because without in principle approval, they cannot proceed for land acquisition. Then they proceeded, give the recommendation, final approval is not there. Now in the process, if somebody suffers, now who will pay the damages and compensations or the land acquisition? This is the two issues.
That's the whole question
Whole
to
question
be decided.
to be decided.
Now,
Because
today-
for their fault, deputy commissioner's fault, you cannot be allowed to suffer or the fault of the armed officers. But whether that will lead to a conclusion that no, these sufferings and damages should be given by directing them to acquire the land. Whether that is permissible
No, now what
under
normally-
the judicial.
Now, what normally happens, if it is not under section 40, if it is said that it is under different, it is not under 40, then if it is not under 40, it's a normal acquisition which take place. Now, your
So,
lordship
for
knows,
that
if
emergency.
it is a normal acquisition,
Therefore, we want
if
to
it
know
is-
that there was an urgency and therefore acquired this land under 41.
no, that is why this notification is under 41. Urgency was there. No, what I am saying, if it is a normal,
Let us forget.
It is suppose, assuming for a moment, suppose the deputy commissioner has in his own apted.
Yes.
41 he has given, there is no request for the requiring authority, nothing was there, then.
Then the ultimately deputy commissioner has to pay to us.
So
That's
that will be
that's the law.
second part.
That's
So-
what they have to
So
pay.
first part is whether we can give a direction for acquisition of the land. And to give the direction, we'll have to have a conclusion that in all meaning and purport, the acquisition was complete. Is that
No,
it?
that is not required. That is not required. Why it is not required? I will show one
No, no,
judgment.
we'll have
What case for all purpose what is required and for what purpose it is not required.
Okay,
I will demonstrate that by a judgment of the Supreme Court. It's not required. Because your lordship will kindly look into and appreciate. This 40 is parametric to a clause of 1894, which is 17 and 17(3). That exists earlier also.
Earlier also.
And that
Because there is
decided
always
by
a-
the apex court.
In an emergency situation, either they
But
can,
now-
either they can make requisition, pay rent, or they can immediately without only 41 notice, they can acquire.
So once, my lord,
Now,
once.
what to be done
You,
today?
well, today, if it is also 40, your lordship doesn't have to look into the background of the entire case. Not required. Once movement is under 40, your
No, we
lordship
need-
is
we-
going
we need
ahead.
Not look into.
Yes.
But if the requiring agency itself says that we are not, this is not a,
When?
then we'll have to see.
No, when? That your lordship will see the bona fide and conduct.
That will
They
see.
cannot make a somersault and say, your lordship will see. They are pointing our bona fide, your lordship will catch hold of their bona fide.
Yes, of course. we'll
Why
definitely-
they are saying that?
Definitely.
Bona fide and conduct is very
We'll
important.
see, we'll definitely.
Today, if that be the case, then you should not have placed before the board. Why that your board has taken all the time they said, yes, board proceeding, board proceeding. What board proceeding, my lord? Today it is before the court.
Okay, let us conclude today. What to be done?
My
We'll
lord,
take it tomorrow is there, your lordship.
my lord, I'm sorry, just a minute. My lord, as my friend has said, my lord, the proposal or the procedure of the board was sent to the ministry, my lord, and ministry rejected, my lord. That should be recorded, my lord. Now, you have said that board procedure was sent to the Union of India, and Union of India, my lord, that was not accepted. That is the submission made by him.
My lord, can
That should be
I
recorded.
just request your lordship? Let us not tomorrow, your lordship will not take, because your
No,
lordship
no,
has to
you
go.
have submitted.
Let
No,
us
no,
on
you have
12,
submitted,
let
sir.
it be on 12.
No, no, you
Even
have said
I'll
so.
come and,
You have
because
said
this is two.
Categorically, you have said.
Take some time.
That's why I'm saying, my lord, it will take some time. So your lordship will please look into
And
it.
we are having on the next week
On-
only 3 days.
That's why
Monday,
I'm saying,
Tuesday, Wednesday.
12, my lord, I'll just argue before this lordship, this 12, this matter, on 12.
Then again, it will be part heard. I'm
No,
not
the part
available.
time, your lordship can take up on 14 and finish it off. What is there, my lord? On 14, 12, I will do my part. 14, because now we know, my lord, what is the point before this court.
My lord,
I have to highlight before this court about the issue in hand. Because your lordship has rightly said that these are the issue which your lordship has to take a decision. Even if there is a sanction, if doesn't send it, then what to do next? Whether a direction can be given that yes, give a sanction. No, I will
12,
tell
12 may not be possible. Not too many matters we have fixed.
when, my lord.
12.
12, my lord.
Well, lordship, keep it and see it on 12, we will try. Because now in your lordship is in a flow. Now we have also have argued considerably, my lord. Please look into the urgency of this particular, otherwise I would not have pressed. This way, that way it may go. It may go against us also, my lord. It may be in favor. We don't know the
Then
result.
if we make it part heard, then we'll have to carry and hear virtually from Guwahati.
No, that's there, my lord. No problem. My lord will
My
do
lord,
one
I'm
thing.
sorry, ma, Barcelona will find it very difficult. Because night shift is very bad, my lord, Itanagar, my lord.
May I?
Can't get-
If you are affidavit to Mr. Das,
My lord.
you are supporting his case.
My lord, if you see
You are supporting your action.
my action,
We are not
because my
saying
lord, we
you are
have
supporting
acted as
No,
per
no,
the,
they
my
are
lord.
supporting their own action.
Their own action.
Their own action.
They are supporting their action.
Their
They are
own
saying
action
that
they are
whatever we have done is
We have done.
on the request of the requiring authority, we'll use the word requiring authority. So therefore,
My lord, initially, my lord, word was not used
No,
as
interesting.
acquiring authority. They
My-
said, my lord, army authority,
No,
which
they-
does not have the power or authority. Then when we
They
produce
cannot.
my state
Today
official,
they
then
have written a letter saying that to withdraw.
there is no provision, they cannot withdraw the judgment of
We
the
are
Supreme
fixing
Court.
it on 23rd of August. Harshwell.
23rd.
It's a holiday in Guwahati.
23rd, Malav,
It's a holiday in Guwahati.
principal seat, Malav, not sure.
Principal seat, we are taking it because we have fixed some other matter. I think election petition is fixed on 23rd.
September.
4 days holidays. If Mr. Das is in India, then we can.
Well, only one request. Let it be on 12 and we want to be on face to year. But it
We
makes
will
lot of.
base on 23rd in
Because
Guwahati.
my learned friend will be also, this is a lot of connection is the problem. I have seen, I had an experience
Yes, Malav.
of in Arunachal Pradesh. Connection is the biggest problem.
Hybrid, Malav is very difficult.
Very, very difficult.
I do not think 12 it will be over.
No, let it, your lordship will, the 14 is there. I'll go and again I'll come back, but I want to finish it off. But I don't want to come again for this case, my lord.
So you want to give a serious burden on this?
No,
15, 16, 17 and 18.
No, my lord, because it's, I have to hear, man, I feel, that's why I thought that, let me finish it off and only troubling your lordship, it is possible, let's take it on 12, let it on 12,
piece. Wednesday.
Monday.
Today is
Today is Thursday.
12th August.
Well, lordship will make it a try and we'll see it, my lord.
Monday.
then I have to be present.
Harder Samland for
Yes.
further hearing on 12. Be ready with all those questions.
Yes.
And if
Yes.
I
We
have
have everything
my
well
lord,
set in our.
I have understood the query that has been
and
put.
keep that notification, that is important.
I'll keep it.
And if any other notification available in this regard,
And I will show the order of the Supreme Court.
Hmm.
There was no sanction.
and where is the division bench judgment?
Division bench is on record. I'll
Okay,
place it.
keep that also and
Because your lordship was,
ask them to properly mark it this file for
Keep-
Monday. And send it to the
Resolution, no.
residents, Bangalore.
running
My
facility.
last friend is saying that the last academic appointment, they are not writing. So in the.
It's okay.
Certain documents be wanted to an RTI, it is not record.
Because
Now they have come to the initial affidavit,
Hmm.
and they said because only anxiety was born. That I am satisfied about. Because that is, because you see, my lord, it was placed into the. Now, the court said, we want to see the records of that. Today you are saying. propose-
as can you have your record also on Monday? You have to record how it proceeded, what are those things?
Yes, sir.
Yeah, okay, yes.
Allow my lord, submission of the image state of there is no section, no except from the authority who is the DEO. Image state officer. In the course of hearing, my lord, out of them, that the notification is not made into the court. That is how under section 40. Now they have. They are changing the. But one thing you know, please, the conduct and both in the.
Of course,
That you also have to do.
of course.
They cannot play around.
Monday after finishing of Monday, after finishing the list, we'll start this method. Huh? After finishing the list, we'll start this method. Okay. Any method left? Yes.
That's the pleasure of the lawyer.
Item number.
That's the pleasure. My lord, of course, this matter.
Mr. Das, no record of sitting till 4:45. 4:45. 3:30, 50 meters are over. Yes.
My lord, I can see there is positive time, my lord, but I would try to conclude only 5 minutes, my lord.
What
My
is
lord,
that?
The issue involved is very simple, my lord. Before, without opening my file, my lord, brief, my lord. I'll just narrate the fact, my lord. I was appointed as contingency staff, my lord, in the year 2002. There
Now
was
your
a,
representation was rejected.
it was rejected,
On what ground?
saying that there was no vacancy.
Hmm.
But after I had applied for RTI, I could found that, my lord, in the year 2013, all these private respondents were given the upgradation.
Okay. Okay, some other day.
My lord, may kindly fix it tomorrow, my lord.
Tomorrow, too many methods are fixed.
Because my lord, this is a poor man, my lord.
No, no, understand, we'll hear you, we'll hear you.
2019 matter, my lord. Issue is, my lord. I
No, no,
think, my
understand,
lord,
I've seen that.
yes, it is very simple, my lord.
Already I
It may
have
go-
two CAVs with me.
It may go against me or
Two, na? Two CAVs. For Saturday, Sunday.
yes, ma'am. I can understand, my lord, but I can also feel
Friday,
Friday, ma'am.
tomorrow, Friday, Monday.
Monday.
We'll take up, not Monday, Monday, that matter, we'll take up on Tuesday. Huh?
My lord,
Tuesday,
Tuesday.
Tuesday.
It's okay, madam. Oblige, madam.
Tuesday. Anything?